You had it at a different time. I had it in my head, it was 8:30, but then I saw Sydney here bright and early at 8, and I thought, and I'm like, oh, it's 8:15. But yeah, I don't have to do the same amount of work as you guys do to be ready for this. So I think we are on live.
Are you recording that?
You got a bite?
I'll tell you the story later when we get off the record.
Okay, I was gonna say, if you, unless you want the world to be able to hear it later.
Well, it was on the record. But
What county?
it was in Franklin County.
Franklin County. Which judge?
Judge Phipps ended up, she denied bond to the guy. He was out on bond previously. He kidnapped the victim. I mean, how unreasonable.
Yeah.
The case is continuing now about bond being denied, the trial being continued. So they started yelling at deputies. Started yelling at everybody. But deputies trying to pull him out of the courtroom. He would get out. So started tossing with the deputies right there.
He did?
Yeah, one of the deputies broke his ankle too.
His ankle? You didn't jump in to try to?
So there was like a hallway, like a door with a window. I was standing at the door at the window. I was like not ready to the court.
Well, yesterday, of course, we have their defense attorney that plays hockey, semi-professional, and he's the goon, and he likes to fight, so he's always fighting.
He is the goon.
I loved it. But he said they're going to be playing in Findlay. He said maybe in November or something. I thought, well, I'll try to go up and see him. It'll be
He's
fun.
been kicked out of asking about his suspension.
Yes, he's had suspensions. He told us that. Yeah, not just the penalty box, but suspensions. That's pretty serious. Yeah. All right, are we ready? Yeah, is she distracting you, or are you okay with having her there?
Oh, it's fine.
Okay. Yeah, she likes
She
you.
looks different without that hair gone.
Oh, I know. She doesn't even look like a Great Pyrenees. She looks, yeah. At first she was a little odd about it, but now I think she's finally used to it. All right, we are on record in State versus Barnes in two cases, 26 CR 020 and 26 CR 041. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. State your name.
John Barnes.
Okay, and you wrote down your address, phone number, email
Yeah.
for me before we went on record. Is all the information on there accurate?
Yes.
And is your physical address and mailing address the same?
Yes.
Okay,
The only thing I didn't put on that, I just remembered,
okay,
apartment C.
okay, I will add that. Thank
It's
you.
just dog, I'm thinking,
Apartment C.
yeah,
Okay, I'll put that right there. Thank you.
Yeah.
And your attorney for the record is?
Scott Petroff on behalf of John Barnes, Stevens, my left.
And for the state?
Yes, Your Honor, Sydney Whiting, Meigs County Assistant Prosecuting Attorney on behalf of the state.
All right, and we are here, Mr. Barnes, because I understand you want to withdraw your previous plea of not guilty and now enter into a plea of guilty pursuant to an agreement you've been able to reach between yourself and the state. Is that correct?
yes, Your Honor.
In order to complete that process, I'll have to ask you a lot of questions. So first, can you hear me?
Yes.
I meant to turn to, you can paste that towards you too. If at any point you cannot hear me, let me know and I will amplify my voice more. I'll get closer to the microphone, whatever it takes. So let me know if you can't hear. Also, if I ask you any question that does not make sense to you for any reason, ask me to restate, rephrase, or to explain the question. Do not answer the question unless you understand it. Will you do that?
Okay, yes, Your Honor.
And if you need to talk to your attorney at any point, let me know that as well, and we'll let you step out and speak to him. Even if it's in the middle of everything, if it just hits you that I really want to ask my attorney something, just say so. We'll let you go speak privately with him. Will you let me know if you need to talk to him?
Yes, Your Honor.
And I need you to continue answering all questions out loud with complete and real words because we are making a record.
Okay.
Anything preliminary from the state or defense?
Thank you.
That's right.
Okay, Mr. Barnes, state your full name, including any middle name or names.
John Edward Barnes.
Have you ever used any other names, aliases, or nicknames?
No.
Is English your first language?
Yes.
Are you the same person that's in the indictments in cases number 26 CR 020 and 26 CR 041?
Yes.
How old are you?
58.
And what is your date of birth?
August 19th, 1967.
And what are the last four digits of your social security number?
7804.
Thank you. How far did you go in school?
Graduated 12th grade.
So can you read and understand written English proficiently?
Yes.
Have you ever served in the military?
Yes.
Are you a citizen of the United States?
Yes.
And thank you for your military service, by the way. Are you under the influence of medications, drugs, alcohol, or any mind-altering substances at this time?
No.
And pursuant to the policy of the court, you underwent a drug screen prior to starting this hearing, and you were negative for all illegal substances and mind-controlling substances, correct?
Yes.
Do you now have or have you ever suffered from mental illness or mental disease?
No.
Are you presently under any type of probation, community control supervision, or on paper in this or any other state?
No.
Has anybody threatened, coerced you, or made you enter into this plea of guilty?
No.
Has anyone promised you anything at all if you enter into a plea of guilty?
No.
The state is going to read into the record what they believe they would be able to prove if the matter went to trial in each of these cases, and then what the plea agreement is. Listen carefully, then I'll ask you some more questions. With that, go ahead, Ms. Whiting.
The state believes that if this case were to go to trial, it would be able to prove counts 1, 2, 3, 4, 5, 6, 7, and 8 of the indictment in case number 26 CR 020. Count 1 of the indictment states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that John Barnes did knowingly obtain, possess, or use heroin, a Schedule 1 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, in violation of section 2925(11)(a) and C6B of the Ohio Revised Code of Felony of the 4th degree. Count 2 states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use fentanyl, a Schedule 2 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, in violation of section 2925(11)(a) and C11B of the Ohio Revised Code of Felony of the 4th degree. Count 3 states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use fentanyl, a Schedule 2 controlled substance, in an amount less than 1 gram, to wit 0.25 grams, in violation of section 2925(11)(a) and C11A of the Ohio Revised Code of Felony of the 5th degree. Count 4 states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use monoacetylmorphine, a Schedule 1 controlled substance, in an amount less than the bulk amount, to wit 0.25 grams, in violation of section 2925(11)(a) and C1A of the Ohio Revised Code of Felony of the 5th degree. Count 5 states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute heroin, a Schedule 1 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, when the offender knows or has reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another person, in violation of section 2925(03)(a)(2) and C6A of the Ohio Revised Code of Felony of the 5th degree. Count 6 states that on or about the 6th day of February 2026 in the county of Meigs and the state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute fentanyl, a Schedule 2 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, when the offender knows or has reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another person, in violation of section 2925(03)(a)(2) and C9C of the Ohio Revised Code of Felony of the 4th degree. Count 7 states that on or about the 6th day of February 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly prepare for shipment, ship, transport, deliver, or prepare for distribution or distribute fentanyl, a Schedule 2 controlled substance, in an amount less than 1 gram, to wit 0.25 grams, when the offender knows or has reasonable cause to believe the controlled substance was intended for sale, resale by the offender or another person, in violation of section 2925(03)(a)(2) C9A of the Ohio Revised Code of Felony of the 5th degree. And count 8 states that on or about the 6th day of February 2026 in the county of Meigs in the state of Ohio. John Barnes did commit the crime of trafficking in drugs and that he did knowingly prepare for shipment, ship, transport, deliver, or prepare for distribution or distribute monoacetylmorphine, a Schedule 1 controlled substance, in an amount less than the bulk amount, to wit, 0.25 grams. When the offender knows or has reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another person in violation of section 292503 A2 and C1A of the Ohio Revised Code of Felony of the 4th degree. And the facts that gave rise to this case are that on February 6, 2025, Sergeant Tracy with the Major Crimes Task Force received a search warrant for the residence at 121 Union Avenue in Pomeroy, Ohio, belonging to John Barnes and being occupied by John Barnes, Austin Clutter, Abigail Braddock, and David Betts. Detectives as well as deputies with the Meigs County Sheriff's Office conducted a search warrant on the residence and detained all individuals. Detectives located multiple firearms in John Barnes' bedroom as well as suspected fentanyl. Detectives also located baggies, oils, and scales consistent with drug trafficking. All evidence was submitted to the BCI crime lab for testing, which revealed that the plastic bag containing an off-white powder was in fact 1.29 grams found to contain heroin and fentanyl. The glass tube containing a clear liquid was found to be 0.25 grams containing the monoacetylmorphine and fentanyl. With that, state believes that it would be able to prove beyond a reasonable doubt counts 1 through 8 of the indictment in case number 26 CR 020. And the state would ask that the court go along with the agreement of the parties, which is that upon defendant's plea to counts 1 through 8 of the indictment, the defendant will be sentenced to community control, and as a condition of that community control, successfully complete inpatient treatment at this steps of recovery. And then further, the defendant would agree to forfeit a Marlin 3030 serial number 260-10243, a Marlin 39A22 serial number 2715590, and an H&R Sportsman 22 serial number 512506 to the Meigs County Sheriff's Office, and also be assessed the court costs in this matter. And then in case number 26 CR 041, the state believes that if this case were to go to trial, it would be able to prove counts 1 through 8 of the indictment. Count 1 states that on or about the 22nd day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly sell or offer to sell heroin, a Schedule 1 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit, 1.04 grams, in violation of section 292503 A1 and C6C of the Ohio Revised Code of Felony of the 4th degree. Count 2 states that on or about the 22nd day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly sell or offer to sell fentanyl, a Schedule 2 controlled substance, in an amount equal to or exceeding 1 gram, but is less than 5 grams, to wit, 1.04 grams, in violation of section 292503 A1 and C9C of the Ohio Revised Code of Felony of the 4th degree. Count 3 states that on or about the 22nd day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use heroin, a Schedule 1 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit, 1.04 grams, in violation of section 292511A and C6B of the Ohio Revised Code of Felony of the 4th degree. Count 4 states that on or about the 22nd day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use fentanyl, a Schedule 2 controlled substance, in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit, 1.04 grams, in violation of section 292511A and C11B of the Ohio Revised Code of Felony of the 4th degree. Count 5 states that on or about the 27th day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly sell or offer to sell heroin, a Schedule I controlled substance, in an amount less than 1 gram, to wit 0.90 grams, in violation of section 292503 A1 and C6A of the Ohio Vice Code of Felony of the 5th degree. Count 6 states that on or about the 27th day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of trafficking in drugs, and that he did knowingly sell or offer to sell fentanyl, a Schedule II controlled substance, in an amount less than 1 gram, to wit 0.90 grams, in violation of section 292503 A1 and C9A of the Ohio Vice Code of Felony of the 5th degree. Count 7 states that on or about the 27th day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use heroin, a Schedule I controlled substance, in an amount less than 1 gram, to wit 0.90 grams, in violation of section 292511A and C6A of the Ohio Vice Code of Felony of the 5th degree. And count 8 states that on or about the 27th day of January 2026 in the county of Meigs and state of Ohio, John Barnes did commit the crime of possession of drugs, and that he did knowingly obtain, possess, or use fentanyl, a Schedule II controlled substance, in an amount less than 1 gram, to wit 0.90 grams, in violation of section 292511A and C11A of the Ohio Vice Code of Felony of the 5th degree. And the facts that gave rise to this case are that on January 22nd of 2026, Lieutenant and Detective Sam Wiedmer with the Meigs County Major Crimes Task Force met with the CI at a predetermined location in which the CI was searched, confirming that there was no contraband in their possession. CI identified John Barnes as who they were going to buy 1 gram of fentanyl for $120. Officers with the Major Crimes Task Force then conducted surveillance during the buy and saw John Barnes and the home at 121 Union Avenue in Pomeroy, Ohio. The CI then met at the predetermined location and all items were collected, and then those items were sent to the BCI crime lab for testing, which showed that the off-white substance was in fact 1.04 grams, found to contain ketamine, heroin, and fentanyl. And then on January 27th, 2026, Detective Wiedmer and Sergeant Tracy with the Major Crimes Task Force met with a confidential informant and set up a purchase of 1 gram of fentanyl from John Barnes for $140. The CI stated that John Barnes wanted to meet at the McDonald's parking lot. The CI was then searched for any contraband and met with John Barnes inside the vehicle at the McDonald's parking lot. The CI was then picked up at and taken to the undisclosed location, and all of the evidence was collected and sent to the BCI crime lab for testing. And the off-white powdery substance was found to be 0.90 grams, found to contain xylazine, heroin, fentanyl, and prophylactic formalin. With that, the state believes that it was able to prove counts 1 through 8 in case number 26CR041. And the state would ask that the court go along with the agreement of the parties, such as that upon defendant's plea to counts 1 through 8 of the indictment, the defendant will be sentenced to community control. And as a condition of that community control, shall successfully complete inpatient treatment at the steps of recovery and also be assessed the court costs in this matter.
All right, anything to add to that, Mr. Petroff?
Nothing for the past, Your Honor.
And Mr. Barnes, the state has read into the record what the plea negotiation results are. Did you hear what was said?
Yes, Your Honor.
Is that the same information your attorney discussed with you before the hearing?
Yes, Your
Was anything different?
Honor. No, Your Honor.
Was anything missing?
No, Your Honor.
Do you have any questions about the recommendations?
No, Your Honor.
Have you read the plea agreements?
Yes, Your Honor.
Has your attorney read them to you or reviewed them with you?
Yes, Your Honor.
Do you understand what each the plea agreement says?
Yes, Your Honor.
Do you have any questions about it at all?
No.
About either of them? Do you understand that while you and the state have presented to the court a recommendation for sentencing, the court does not have to accept it? Now, knowing the court is not obligated to follow the plea recommendations, do you still wish to proceed?
Yes, Your Honor.
I sense some hesitation. Do you need to talk to your attorney?
No.
Okay, I'm going to ask that counsel add up the maximum consecutive sentence, because didn't do that math ahead of time. So when I get to that part,
But I kind of remember it's 10 years in one case.
I just want to be able to articulate that when we get to that point in my colloquy, and I just haven't to do math yet. So if you'll be working on that, I'd appreciate it. Now, because the plea agreement is for for community control, the court must have a pre-sentence investigation report prepared for consideration at sentencing unless it's waived by all necessary parties. Do you understand that?
Yes, sir.
Do you understand what a pre-sentence investigation report is?
Yes, sir.
And was the intent to have one prepared and have separate sentencing, or was the intent to waive the preparation and consideration of the pre-sentence investigation report?
You prepared with PSI this one.
You agree with that, sir, Mr. Barnes?
Yes, sir.
Okay, and is the state also waived?
Yes, Sean.
Mr. Barnes, do you understand this is a jointly recommended or agreed sentence?
Yes, sir.
Do you understand what that means?
Yes, sir.
Have you had enough time to consult with your attorney before proceeding?
Yes, sir.
Has your attorney answered all of your questions?
Yes, sir.
Have you reviewed the discovery, indictment, lab reports, and other legal documents with your attorney?
Yes, sir.
Ms. Whiting, has the state of Ohio disclosed all Brady materials?
Yes, Sean.
Mr. Barnes, are you satisfied with your attorney?
Yes, sir.
Now I'm going to go through all those counts again, so listen carefully. Do you understand the allegations in case number 26CR020 are that you did on or about and count 1, that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use heroin, a Schedule 1 controlled substance in an amount equal to or exceeding 1 gram, but less than 5 grams, specifically or to wet 1.29 grams, in violation of Section 2925.11a and C6b of the Ohio Revised Code, being a felony in the 4th degree.
Yes.
Do you have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 2 of that indictment are that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use fentanyl, a Schedule 2 controlled substance in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, in violation of Section 2925.11a and C11b of the Ohio Revised Code, a felony of the 4th degree.
Yes, sir.
Do you understand do you have any questions about the elements of that offense?
No.
Count 3, do you understand that the allegations are that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use fentanyl, a Schedule 2 controlled substance in an amount less than 1 gram, to wit 0.25 grams, in violation of Section 2925.11a and C11a of the Ohio Revised Code, being a felony of the 5th degree?
Yes, sir.
Do you have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 4 are that you did on or about the 6th day of February 2026 here in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use monoacetyl morphine, which is commonly referred to as 6-MAM, a Schedule 1 controlled substance in an amount less than bulk, specifically or to wit 0.25 grams, in violation of Section 2925.11a and C1a of the Ohio Revised Code, of felony of the 5th degree?
Yes, sir.
Count 5, do you understand the elements of count
Yes.
4? Any
Yes.
questions about the elements?
No.
Okay. Count 5, do you understand the allegations are that you did on or about February 6, 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute heroin, a Schedule 1 controlled substance in an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.29 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by yourself or another person, in violation of Section 2925.03a2 and C6a of the Ohio Revised Code, being a felony of the 5th degree?
That one I'm confused. That was February 6th?
That one is February 6th.
No. That's
There's
Mhm.
trafficking.
Oh,
There's trafficking, the one count, the one
I
indictment's
understand.
all
I'm sorry.
February
Sorry.
6th, which is the search warrant,
Yeah, so there's a series of counts based on interactions with the
CI, and that's the other indictment.
Correct, and then there's a series of counts based on the execution of the search.
I got you. I'm so sorry.
So this was in the search warrant one.
I-
It actually happened second, even though it was the indictment case
Forgive me.
first. Okay,
I
but
just got concerned about something.
it is very, yeah, you've got a lot of counts.
I know, I'm scared.
Yeah.
Yeah, I mean, yes, I understand, Your Honor.
Okay, do you have any questions about the elements of
No,
count 5?
no.
Okay, do you understand the allegations in count 6 are that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly obtain, prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute fentanyl, a Schedule II controlled substance in an amount equal to or exceeding 1 gram but less than 5 grams, to wit 1.29 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by yourself or another person, in violation of section 2925.03A2 and C9C of the Ohio Revised Code, being a felony of the 4th degree.
Yes, Your
Do
Honor.
you have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 7 of that indictment are that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute fentanyl, a Schedule II controlled substance in an amount less than 1 gram, to wit 0.25 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by yourself or another person, in violation of section 2925.03A2 and C9A of the Ohio Revised Code, of felony of the 5th degree.
Yes, Your Honor.
Have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 8 of the indictment are that you did on or about the 6th day of February 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute monoacetyl morphine, commonly referred to as 6-MAM, a Schedule I controlled substance in an amount less than bulk amount, to wit 0.25 grams, when you knew or had reasonable cause to believe the controlled substance was intended for sale or resale by yourself or another person, in violation of section 2925.03A2 and C1A of the Ohio Revised Code, a felony of the 4th degree.
Yes, Your Honor.
Do you have any questions about the elements of that offense?
No.
Do you understand you were also indicted with specifications as to counts 1 through 8 regarding the 3 firearms in the possession of you at the time of the search warrant, and the request that they be forfeited to the Meigs County Sheriff?
Yes, Your Honor.
And with regards to the second indictment, which is chronologically what happened first, which with the CIs, as I understood it, so the facts. Do you understand the allegations contained in count 1 are that you did on or about the 22nd day of January 2026 in Meigs County, commit the crime of trafficking in drugs, and that you did knowingly sell or offer to sell heroin, a Schedule I controlled substance, an amount equal to or exceeding 1 gram, but less than 5 grams, to wit 1.04 grams, in violation of section 2925.03A1 and C6C of the Ohio Revised Code, of felony of the 4th degree.
Yes, Your Honor.
Have any questions about the elements of that offense? Do you understand the allegations contained in count 2 of that indictment are that you did on or about the 22nd day of January 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly sell or offer to sell fentanyl, a Schedule II controlled substance, an amount equal to or exceeding 1 gram but less than 5 grams, to wit 1.04 grams, in violation of section 2925.03A1 and C9C of the Ohio Revised Code, of felony of the 4th degree.
Yes, Your Honor.
Do you have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 3 are that you did on or about the 22nd day of January 2026 in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use heroin, a Schedule I controlled substance, in an amount equal to or exceeding 1 gram but less than 5 grams, to wit 1.04 grams, in violation of section 2925.11A and C6B of the Ohio Revised Code, being a felony of the 4th degree.
Yes, Your Honor.
You have any questions about the elements of that offense?
No.
Do you understand the allegations contained in count 4 of the indictment are that you did on or about the 22nd day of January 2026 in Meigs County, Ohio, commit the crime of possession of drugs, and that you did knowingly obtain, possess, or use fentanyl, a Schedule II controlled substance, in an amount equal to or exceeding 1 gram but less than 5 grams, to wit 1.04 grams, in violation of section 2925.11A and C11B of the Ohio Revised Code, a felony of the 4th degree.
Yes, Your
Have any questions about the elements in count 4?
Honor.
Do you understand the allegations contained in count 5 of this indictment are that you did on or about the 27th day of January 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs, and that you did knowingly sell or offer to sell heroin, a Schedule I controlled substance, in an amount less than 1 gram, to wit 0.90 grams, in violation of section 2925.03A1 and C6A of the Ohio Revised Code, a felony of the 5th degree.
Yes, Your
Have
Honor.
any questions about the elements of count 5?
No, Your Honor.
You understand the allegations contained in count 6 or that you did honor about the 27th day of January 2026 in Meigs County, Ohio, commit the crime of trafficking in drugs and that you did knowingly sell or offer to sell fentanyl, a Schedule II controlled substance in an amount less than 1 gram, to wit 0.90 grams, in violation of section 2925.03A1 and C9A of the Ohio Revised Code, a felony of the 5th degree.
Yes, Your Honor.
Do you have any questions about the elements of that offense? You understand the allegations contained in count 7 of that indictment are that you did honor about the 27th day of January 2026 in Meigs County, Ohio, commit the crime of possession of drugs and that you did knowingly obtain, possess, or use heroin, a Schedule I controlled substance in an amount less than 1 gram, to wit 0.90 grams, in violation of section 2925.11A and C6A of the Ohio Revised Code, a felony of the 5th degree.
Yes, Your Honor.
Have any questions about the elements of that offense? Do you understand the allegations contained in count 8 are that you did honor about the 27th day of January 2026 in Meigs County, Ohio, commit the crimes of possession of drugs and that you did knowingly obtain, possess, or use fentanyl, a Schedule II controlled substance in an amount less than 1 gram, to wit 0.90 grams, in violation of section 2925.11A and C11A of the Ohio Revised Code, a felony of the 5th degree.
Yes, Your Honor.
Have any questions about the elements of that offense?
No.
Do you understand that if you plead guilty to these offenses, you will be making a complete admission that you committed the allegations contained in those 2 indictments?
Yes, Your Honor.
Do you understand that if you plead guilty, the court will enter a judgment of guilt against you and may proceed to sentence you immediately?
Yes, Your Honor.
Do you understand that if you did wish to pursue an affirmative defense, it would be your obligation to prove the existence of that affirmative defense to the jury by a preponderance of the evidence, although it always remains the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand by pleading guilty, you'll be waiving your right to appeal any adverse evidence or other pretrial rulings, such as a motion to suppress or the like.
Yes, Your Honor.
Do you understand by pleading guilty, you'll be waiving your right to have any pending evidentiary motions ruled upon?
Yes, Your Honor.
Do you understand the penalties that could be imposed in case number 26CR020, count 1, possession of drugs, a felony of the 4th degree, would be 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months in prison, up to $5,000 fine, or both?
Yes, Your Honor.
Do you understand the potential penalties that could be imposed for count 2, possession of drugs, a felony of the 4th degree, would be an additional 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 18 months in prison, a fine of up to $5,000, or both?
Yes, Your Honor.
Do you understand the potential penalties that could be imposed for count 3, possession of drugs, a felony of the 5th degree, in violation of Ohio Revised Code section 2925.11A, would be a possible penalty of 6, 7, 8, 9, 10, 11, or up to 12 months in prison, up to $2,500 fine, or both?
Yes, Your Honor.
You understand the potential penalties for count 4, possession of drugs, a felony of the 5th degree, would be another 6, 7, 8, 9, 10, 11, or up to 12 months in prison, up to $2,500 fine, or both?
Yes, Your Honor.
Do you understand the potential penalties for count 5, trafficking drugs, and other felony of the 5th degree, would be another 6, 7, 8, 9, 10, 11, or up to 12 months in prison, up to $2,500 fine, or both?
Yes, Your Honor.
Do you understand the potential penalties in this indictment for count 6, trafficking of drugs, a felony of the 4th degree, would be another 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months in prison, a fine of up to $5,000, or both?
Yes, Your Honor.
Do you understand the potential penalties in this indictment for count 7, trafficking drugs being a felony of the 5th degree, would be 6, 7, 8, 9, 10, 11, or up to 12 months in prison, a fine of up to $2,500, or both?
Yes, Your Honor.
Do you understand the potential penalties for count 8 in this indictment would a felony of the 4th degree, would be another 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 18 months in prison, a fine of up to $5,000, or both?
Yes, Your Honor.
Moving on to the indictment in 26CR041, do you understand the potential penalties for count 1, trafficking drugs, would be as a felony, the 4th degree, would be 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months in prison, a fine of up to $5,000, or both?
Yes, Your Honor.
Do you understand the potential penalties for count 2, trafficking drugs, a felony of the 4th degree, would be 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months in prison, up to $5,000 fine, or both?
Yes, Your Honor.
Do you understand the potential penalties for count 3 in that indictment, possession of drugs, another felony of the 4th degree, would be another possible 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 18 months in prison, a fine of up to $5,000, or both?
Yes, Your Honor.
Do you understand the potential penalties for count 4, possession of drugs and other felony? The fourth degree would be another potential sentence of 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months in prison, a fine of up to $5,000 or both.
Yes, Your Honor.
Do you understand the potential penalties for count 5, trafficking in drugs is another felony? The fifth degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, or up to 12 months in prison, a fine of up to $2,500 or both.
Yes, Your Honor.
Do you understand the potential penalties for count 6, trafficking in drugs, another felony? The fifth degree would be another 6, 7, 8, 9, 10, 11, or 12 months in prison, another fine of up to $2,500 or both.
Yes, Your Honor.
Do you understand the potential penalties for count 7 is another felony, the fifth degree, with another potential penalty that's 6, 7, 8, 9, 10, 11, or 12 months in prison, a fine of up to $2,500 or both.
Yes, Your Honor.
And finally, do you understand the potential penalties in count 8 of this indictment are that you could be it's a felony of the fifth degree with another potential penalty of 6, 7, 8, 9, 10, 11, up to 12 months in prison, up to $2,500 a fine, or both.
Yes, Your Honor.
These are not offenses, however, which carry a mandatory prison sentence. So do you understand the court can consider placing you on a community control sentence?
Yes, Your Honor.
Do you understand you could also be considered for other things like judicial release and other early release programs, since it's not a mandatory prison sentence?
Yes, Your Honor.
Do you understand that you might also be eligible for earned credit against your sentence, depending upon the nature of your conviction and your conduct while in prison?
Yes, Your Honor.
Is there any restitution sought in either case? I didn't see any.
No.
Okay. Mr. Barnes, do you understand, unless waived, the court will order you to pay the court costs?
Yes, Your Honor.
Do you understand that in each of these cases, you may have to serve a period of post-release control as part of your sentence after being released from prison?
Yes, Your Honor.
Since all the cases involve a felony of the fourth degree or a felony of the fifth degree, the maximum, they both are discretionary post-release control of PRC. They're not mandatory or required, but if they are imposed, you understand it's for a maximum of 2 years
Yes.
for the PRC or post-release controller. Do you understand if you're placed on post-release control under the authority of the parole board, you could be returned to prison for up to 9 months for each violation of the rule if your stated prison term equals or exceeds 18 months.
Yes, Your Honor.
Do you understand you could be returned to prison for up to 50% of your prison sentence for all violations committed?
Yes, Your Honor.
Do you understand that as a condition of your post-release control supervision after release from prison, the adult parole authority may require you to wear a GPS electronic monitoring device of some sort?
Yes, Your Honor.
Do you understand if you're convicted of a new felony while on post-release control, that in addition to being punished for the new offense, upon proper proof, the sentencing court could add an additional consecutive or stacked prison term of 1 year or what time remains on your post-release control term, whichever is greater?
Yes, Your Honor.
Do you understand that by pleading to more than one offense, the court must decide whether to run those sentences concurrently, counted together or at the same time, or consecutively, one after the other, or stacked?
Yes, Your Honor.
Do you understand the difference between concurrent or consecutive sentences?
Yes, Your Honor.
You understand this means you could possibly serve a minimum concurrent sentence in all of these of 6 months and a maximum aggregate consecutive sentence if they were all stacked on top of each other of 10 years even, 10 years even. You understand that?
Yes, Your Honor.
Do you understand the offenses in each case being felonies 4 and felonies of the fifth degree carry presumptions in favor of community control?
Yes, Your Honor.
Do you understand that that means the court can consider placing you on a community control sentence for up to 5 years?
Yes, Your Honor.
Do you understand that if you are placed on a community control sentence, you will have to abide by all the probationary conditions as established by the court?
Yes, Your Honor.
Do you understand if the court places you on a community control sentence or a felony offense, a prison term would be reserved as the underlying term?
Yes, Your
It
Honor.
will be all those ones we went through. There's a lot of prison that would be reserved.
Don't want you to go through those.
Okay, you don't. I
No.
understand. Do you understand if the court places you on a community control sentence and then you violate the rules, violate the law, or leave the state without permission, the court can impose more restrictive sanctions, including the imposition of local jail time or other residential sanctions, may extend your probationary terms to the maximum, or even impose all or part of the reserved sentence. So you're looking at up to 10 years if you violate the terms and conditions. You understand that? Do you understand that you may or may not be eligible for judicial release?
Yes, Your Honor.
Do you understand that while you may file a motion for judicial release, there's never any guarantee the court would grant your request?
Yes, Your Honor.
Do you understand the court would have to have either a pre-sentence investigation report or a post-sentence investigation report to even consider a request for judicial release?
Yes, Your Honor.
Do you understand there were specific specifications regarding forfeiture of the firearms, which as part of your plea agreement that they would in fact be the 3 firearms listed would be forfeited to the Meigs County Sheriff?
Yes, Your Honor.
Do you understand that your plea cannot be accepted by this court unless you understand you're waiving important constitutional rights?
Yes, Your Honor.
Do you understand you have the right to a trial by jury of 12 people?
Yes, Your Honor.
Do you understand that all the jurors must agree that the state of Ohio has proven your guilt beyond a reasonable doubt before you can be convicted?
Yes, Your Honor.
Do you understand that at trial, it is the state of Ohio that has the obligation to prove your guilt beyond a reasonable doubt as to each element of each crime of which you are charged?
Yes, Your Honor.
Do you understand that you have the right to the assistance of an attorney throughout your trial?
Yes, Your Honor.
Do you understand your attorney has the right to confront, cross-examine, or ask questions of any witness who testifies against you at trial?
Yes, Your Honor.
Do you understand you have the right to something called compulsory process, which is the right to compel, require, demand, or require, make witnesses attend the trial through the issuance of subpoenas to make sure they are in court when you need them?
Yes, Your Honor.
Do you understand that you cannot be forced to testify against yourself at trial?
Yes.
Do you understand you have the right to testify if you want after consulting with your attorney?
Yes, Your Honor.
Do you understand if you elect not to testify at trial, your silence cannot be used against you in an attempt to prove your guilt?
Yes, Your Honor.
Do you understand each of these rights?
Yes.
Do you have any questions about any of these rights? Do you understand that if you plead guilty, you'll be waiving all of these important constitutional rights?
Yes, Your Honor.
Do you understand by pleading guilty, you will lose some of your civil rights as well, which means you may not vote, serve on a jury, hold public office, or work as a public employee, and you may be denied a license to engage in certain professions?
Yes, Your Honor.
Do you understand your felony convictions would prohibit you from owning a firearm?
Yes, Your Honor.
Do you understand that while Ohio law does permit termination of weapons disability under certain limited circumstances, you would still be subject to prosecution under federal law unless you obtained a separate relief from disability under federal laws?
Yes, Your Honor.
Do you understand based upon your convictions, you may or may not be eligible for an expungement or sealing of your record at a later date?
Yes, Your Honor.
Do you understand that in addition to any forfeiture specifications in the indictment, the court may order forfeiture of any contraband, property that is illegal or in possession of illegal drugs, unlawful weapons, or counterfeit items, any proceeds acquired as a result of the offense, including money obtained through the crime, and any instrumentalities, property used or intended to be used to commit the offense proportional to the offense?
Yes, Your Honor.
Do you understand the following firearms do restrict you federally and on a state level?
Yes, Your Honor.
Do you understand that your civil right restrictions and losing some of those? Is that? Do you understand specifically with regards to your right to vote that that right may be suspended while you are incarcerated, that's restricted upon your release from confinement, even if you're still on parole, post-release control, or community control? However, your voter registration is canceled upon your conviction and must be re-registered before you can vote. I'm sorry, you need to be muted, whoever's in here. Oh, that's with Judge Wallace. Okay, I'm sorry. I can take a recess out of here if we need to. You want me to do that?
He muted himself.
Okay. I'm just going to finish up the civil restrictions. Do you understand your right to serve as a juror and to hold public office is not restored until you have received a final release from the adult parole authority or completed all post-release control or community control sanctions?
Yes, Your Honor.
You understand that you would be prohibited from circulating or signing nominating petitions, voter registration applications, or ballot initiative petitions?
Yes, Your Honor.
Do you understand each of these civil right consequences?
Yes, Your Honor.
Do you understand that if you hold any professional licenses in Ohio, including but not limited to licenses to practicing medicine, nursing, law, pharmacy, social work, counseling, teaching, or to serve as a peace officer, and are convicted, it'll be reported to your licensing board and may affect your ability to keep your license?
Yes, Your Honor.
Do you understand that any fine, court costs, restitution, and other financial sanctions ordered in connection with your convictions remain unpaid? The state of Ohio may place a block on your ability to register your motor vehicles or transfer its title until the amount is paid in full.
Yes, Your Honor.
And do you have any questions about all the potential civil liabilities in these cases?
No, Your Honor.
Do you understand if you do that you don't necessarily lose your right to appeal if you plead guilty?
Yes, Your Honor.
Do you understand, depending upon the outcome of your case, you may possess the right to appeal this court's decision?
Yes, Your Honor.
Do you understand that any appeal in a criminal case must be filed within 30 days after you are sentenced?
Yes, Your Honor.
Do you understand if you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds?
Yes, Your Honor.
We're going to take a break so the visiting judge can handle some of his matters. When I come back, what I'm going to be asking you to do, and you may want to work with your attorney on that, is I'm going to ask you to explain what happened on each of the dates with regards to each count. So you're going to have to tell me, hit the elements of each of those and tell me specifically what you did and with what drugs and the weights and where you did those specifically. I'm looking to see if each of these events happened in Meigs County. So you can prepare for that while I step away. Is this a criminal case or civil case?
So,
It's civil. So I'm going to step away. It looks like maybe I'm needed in chambers.
If you have time, yes.
Yeah, okay, we'll do that and be back with you in a moment, Mr. Barnes.
All right, please. Who's the team? Feel like Jim Jordan and the AG combined, this is US. Oh my gosh, got hair.
all right, Judge Wallace, if you want to unmute, we can go ahead and have that hearing. Our plea started later than we anticipated.
Okay. Yeah, I've unmuted.
Okay. I don't know, Mr. Edwards, are you on Dotson versus Smith?
Yes.
Okay, and then there was someone else, but I don't know.
Yeah, that was, I think, Judge Lowe.
Let me
Yeah, he was here. I don't see him anymore.
yeah, I don't either.
Talk to you, Mr. Barnes.
Thank you, sir.
We're right back. We still got board with it. That's a policy.
Let's see what the chat is. No, that's different. Anybody on the Dotson versus Smith case can go ahead and unmute and show your video.
Yeah, I still don't see
there we
Mr. Lowe, so maybe we could.
He's on there. He was just.
Oh,
There he is.
here he is. Okay, very good. He needs to unmute. There we are.
Yep.
I think we're unmuted. Okay. I think we have everybody, do we not? So we're here on Jane Dotson and Troy Smith, plus Sheriff's Department and Meigs County and the Board of Commissioners, etc. All right. This is a case that was filed by Mr. Lowe. I believe it's a personal injury case. Is that correct, Mr. Lowe?
Yes, Your Honor.
All right. And we do have an answer. All right. So it looks like we have any problem with service, Mr. Lowe?
No, I think everybody's served.
Okay. Service is complete. All right. Any thoughts at this point about either amending the complaint or perhaps amending the answer? I'll go with you first, Mr. Lowe.
don't think we need to amend the complaint, Your Honor.
Okay. None. All right. Mr. Edwards, anything about amending, sir?
No, Your Honor, not this time.
Okay, so you decide it's going to amend, it looks like. All right, so at this point, I think the pleadings are set. Good. All right. Any thoughts about any dispositive motions?
Defendants would like a date, Your Honor.
What was that? I'm sorry.
The defendants would like a date for a dispositive motion deadline.
Oh, okay. I'm sure we can set that. So you're obviously considering perhaps dispositive motions of some sort?
Yes, Your Honor.
Okay. All right. How much time would you need? Keep in mind here at this point, I don't think there's been a lot of discovery. Has there been?
No, so we would need to
Probably a
whenever
little ways out then.
yeah, whenever discovery ends.
Okay, so
probably
maybe we'll look at
60
the discovery deadlines first, and then we can look at dispositive motions. Okay. All righty. Is discovery commenced at all?
No, Your Honor.
No.
No? Okay. Hopefully it'll commence soon. This thing's been in the offing here since April. But of course, looks like the answer was just filed here earlier this month. So are we going to have the interrogatories in the case?
I would imagine, yes, Judge.
Yes, Your Honor.
Okay. All right. How long do you think it'll be before you can get those out, Mike?
We're kind of in a bad spot in here, probably 60 days anyway, Judge.
60 days. Okay. So I'll expect that you'll get those out here in the next 60 days. And then going to take at least a month for people to respond to them. So at this point, we're talking about at least 3 months out. And so that's essentially August will be upon us soon. So that's talking about the end of October then. All right. And so perhaps I will set a deadline for dispositive motions, maybe of perhaps December, perhaps 1st, or is that too ambitious?
I think that may be a little ambitious,
A
depending
little
on
ambitious. Okay,
how
so
discovery
maybe.
goes.
Okay, so yeah, maybe we'll, if you think that, I want to prod people along, but I don't want people frantic necessarily to get this stuff done unless they procrastinate like there's no tomorrow, which wouldn't be the first or last time I've seen that. Maybe January 15th of 2027. I'd give everybody another month and a half or so.
Obviously, that's fine with us, but we're not the ones that likely to be filing one.
Right. Yeah, I understand.
January.
Yeah.
That works for defendants, Your Honor.
Okay. So we'll set a summary judgment deadline here for January 15th. If you have a good cause to extend that, you may be able to convince me to extend it, but let's get that set. So I expect the discovery will commence soon and will be finished by about that time. Probably the only people that might not be reasonable to expect that be done on would be perhaps medical depositions. Usually people save those for toward the end because they're expensive, as we well know. All right, so I'll set the deadline for discovery for, I don't know, maybe January 1st. Is that enough time everybody think to get the discovery done? That's understanding, of course, that we're not talking about medical depositions.
Yeah, that would be fine if we're not talking about the medical deposition.
Okay, all
I
right,
agree as well.
all right, yeah, good. Yeah. All right. Is it possible this case might be disposed of through negotiations or some other means besides trying it?
We would hope so, but I mean, you know, the issue, we recognize the issue is going to be the qualified immunity issue, really.
Yeah. Yeah, I understand this is kind of like war, and what I mean by that is that the enemy gets a vote.
Right.
Right. Something I think sometimes our politicians don't understand. Yeah. All right. So negotiations, once things settle down, may be possible. We'll see what happens on that. And of course, there's immunity questions. So court will deal with those in due course. That's probably what the summary judgments will be about. All right. If we are so unlucky as to have to try this, how long do you think it will take? I'm not going to super hold it to you. I understand it's early.
I don't know that that part of it would be that difficult to try. I mean, there's a video of it, and it'll be what it'll be. But you know, anytime you try something like this, you're always guessing a week. But
Less than a week. Okay, so 4 or 5 days
Yes.
on the outside.
that's my guess.
Okay. And how about you, Mr. Edwards?
I would guess too, about a week, Your Honor.
A week? Okay,
Mhm.
so 5 days. Okay, and I would imagine it's going to go to a jury if it goes. All right, 5-day jury trial. So I think it's a little ambitious to look at setting that now. See, this was filed April 20th. So we're probably talking about if we try this thing, maybe this time next year, maybe a little later, maybe August next year.
That sounds like an educated guess.
What was that? I'm sorry.
That sounds like an educated guess, Judge.
Yeah. Okay. All right. Would you agree with that, Mr. Edwards?
Yes, Your Honor.
All right. Okay. So why don't we tentatively look at something in August, perhaps of 2027? Give us a date. Maybe I'll look at setting a date. That way we've got something down and people have something to work toward. Okay. All right. Anything else we can or should look at today? Obviously, the discovery has not commenced, so nobody's yelling at each other about discovery yet. Hopefully that won't happen. Hopefully everybody will cooperate with each other on discovery.
We'll try to, obviously.
All right, very good. You all both seem like reasonable people, so I would hope that we'll be able to work that kind of thing out. All right. Anything else we need to cover today?
Not from us, Judge.
No. All right, Mr. Edwards, anything else, sir?
Not that I can think of, Your Honor.
Okay. All right. All right. So at this point, thank you very much. And perhaps we should look at, while we're thinking about it, perhaps another pretrial or something like that. Perhaps late this year. Make sure things are progressing.
Yeah, that's fine. What do you have in mind?
Yeah, we can probably try to do that by Zoom again, so
Yeah.
people are not traveling long distances. Except for a medical appointment, my December is clear. So I think we can pick just about any date in December. So does anybody have anything hard and fast in December that they can't, don't worry, I'm not gonna schedule this like the day before Christmas or anything crazy like that, so.
That takes all the fun out of it, Judge.
Right,
Christmas
okay.
Eve are always wonderful.
All right, I'll probably talk about something in early December, like maybe the 10th or 11th or something. All right. So it doesn't sound like anybody's got anything hard and fast then. So any date we probably set during the week of December 7th through the 11th will probably be fine.
Okay.
Okay.
Looks okay, yes.
All right, good. All right. If there's nothing else, I'll thank you. And both of you, all of you have a good day.
Thank you, Judge. Take care.
Yes. Yes, you too. Bye-bye.
We're gonna talk to Jay Humlin about the offer, wonder about that. Mr. Barnes was coming to say that, I figured it'll be a few minutes.
Yeah, they probably will.
All right.
I've got to all of them, right?
The attorneys, yeah, you know,
Supposed to be. Maybe, fuck it.
Figure out what you can do remotely. Yeah. In the meantime. And go ahead and get. Getting fancy around here. Okay, so I need to measure for, we're gonna put chairs down through here, wherever we can put additional chairs. Here and in the jury room. I need to figure out how many chairs we need to get, so.
Won't the jury use the jury room?
Well, not until they're actually seated. Thank you, Judge. So do you think probably not start until?
I would put anything.
All right.
Go to the bottom of the ring.
She's got, mute this, because we're live still, I think.
Go.
Record's on.
All right, we are back on record. Check something real quick. Yes, we're back on record in State versus Barnes. Thank you for your understanding of the visiting judge coming in on taking care of his case. While we were off record, it was pointed out to me that when we had the discussion on the possible maximum penalties if the cases ran consecutively to one another. Because of merger issues, you originally were told up to 10 years if everything ran consecutively. However, I think the parties have agreed that the maximum consecutive, if they ran consecutive, would be 6 years rather than, so I want to make sure I advised you properly. Anything, further explanation beyond that you want me to cover, either state or defense?
No, you're not.
As I indicated, we stopped at the point in which I want you, in your own words, to tell me what happened at each of the dates and locations, and make sure that you meet all the elements of each count, and that it happened in Meigs County. I've asked your attorney kind of to walk through those with you, and we can start with whichever case you want. Just tell me which one you're going to talk about first. If you want to go chronologically.
We'll go 26-0-0-2-0, that's what I've got pulled up.
Okay, that's fine.
So this was the search.
Search warrant.
John, you and I talked in the hall about the facts that led to these cases. Remember that conversation?
Yes.
Okay, so what we're gonna start with, we remember that there's two sets of charges. One set of charges was for search warrant execution. Remember that?
Yes.
And that was February 6th.
Yes.
Okay, so we're gonna go through that, but so big picture, there were essentially two items that were found there. Is that correct?
Yes.
Okay, and one of those was a baggie, correct?
Yes.
That was 1.29 grams of that baggie.
Okay. Yes.
And then one was a syringe.
Yes, the one. Yeah.
And
Loaded up.
okay, and that was 0.25 grams of substance, right?
Right.
Okay, so now we're gonna go through each count and we're gonna identify which count goes to which item, okay? Count one, and just
I don't know why it's doing that. Sorry. I allow it to transcribe because it helps me find that.
also for the record, all of these things happen in Meigs County, is that correct?
Yes.
Okay, so count one is for possession of drugs for 1.29 grams of heroin.
Okay.
Do you recall that?
Yes.
Was that the bag?
Baggie. Yes. Yes.
Count two is for possession of 1.29 grams of fentanyl. What is that from?
Same baggie.
Okay. Count three is for possession of drugs, 0.25 grams of fentanyl, which
Syringe.
that's the syringe. And count four is for possession of drugs of this mono MAM thing. And that is for 0.25 grams. Which was that?
That was the syringe too.
Okay. Count five, trafficking in drugs, 1.29 grams of heroin. Which item was that?
Baggie.
Bag.
And specifically,
But that was,
let's go through the counts 1, 2, 3, and 4. I appreciate that 1 and 2 were the baggie and 3 and 4 were the loaded syringe.
I skipped which, so,
What's up, were they in his possession?
okay.
Those elements.
Did you, where was,
that was my personal stuff that I was using on.
okay,
It's on
so
the bed.
it was on the bed. So counts 1, 2, 3, and 4 were all possession. Okay,
Yeah,
and,
they were both on the bed.
okay.
And they're
What bed?
in your possession?
My bed, yes. In my bedroom.
So you possessed them?
Yes.
Counts 5, 6, 7, and 8 are gonna be for the same items, but for trafficking, and we've talked about how they charge these in the alternative, okay?
Right, right. Yeah.
And you agree that you had trafficked previously? correct?
Yes,
Okay.
yes.
So count 5 is gonna be for 1.29 grams of heroin, and with trafficking, and which item was that?
The baggie.
Okay. Count 6, trafficking, fentanyl, 1.29 grams.
Baggie.
7, trafficking, 0.25 grams fentanyl.
Yes, the syringe.
Okay. Count 8, trafficking is that MAM stuff, the 0.25 grams.
Syringe.
Okay, and you agree that you trafficked those items as well as possessed them?
They were prepared for potential trafficking, you
They were-
know, because it was that they were,
That's where I guess I'm
That-
confused. I-
that-
So did
they
you-
were
did you
prepared for
transport-
shipment, transport, deliver, preparation for distribution.
Yes, it is. In the end of January, you had gone somewhere other than Meigs County to pick up some drugs
Yes,
and bring them back.
yes,
Okay, and these were some of those drugs.
yes.
So you had transported them. And shipped
From
them.
Dayton did it,
Okay.
yes.
And with intent that you could use some and you could sell some.
Right, right. I was using,
Yes.
the codefendant was selling.
So is the state satisfied then?
But I did as well.
Yes.
Because like the girl I was with at the time, she was sick all the time, so I was giving her. Now I know what that's called. That's called enabling. I did not realize. I had that pointed out to me. That's what I was doing and I argued it for, believe me, I struggled with that for a minute and then it finally hit me. I'm like. Yeah, without me, I was enabling it. I shouldn't have. And then she would call me up, said she was sick.
So that was part of your distribution was to your
Right.
companion.
I'm getting ahead of myself.
And this is, actually, this is now he's talking about the facts of the other case.
Okay, that's fine.
So, if the court's okay. we
Yes,
can
move on
go
to-
to that right now.
Oh, four.
26 CR 041,
Yes.
okay?
Okay.
Now you were talking about you were enabling a young lady, you were providing some drugs. to her,
Yes,
correct?
yes.
Is that this person that was in this indictment you were alleged?
I'm pretty sure, sir. Yeah, because that's the only person I ever.
So you would've-
So I wasn't like selling a bunch of people. That was it.
Okay, so let's go through these one at a time. There's 2 counts, okay? And, or, 2 sets of dates in this indictment, okay?
Right.
One set of dates is from January 22nd and one set of dates is from January 27th, okay?
Yes,
So count 1 is from January 22nd. It's for trafficking in drugs, for 1.04 grams of heroin. Is, do you recall
Yeah.
that date selling those, and
Yes.
that was a bag of drugs you sold?
yes. I didn't have anything on my possession to give her.
Okay.
So I
So,
got it next, in my house next door to me. Got it.
and what county was that in?
Next county.
Okay, count 2, trafficking in drugs, January 22nd. Fentanyl, 1.04 grams. Is that the same bag? as
Same,
just-
yeah, same baggie, but yeah.
Now,
I did
They
the
were
same
mixed
thing.
together.
count 3 is for possession of 1.04 grams of heroin on January 22nd. So when you traffic that bag, did you possess it?
Yes,
Okay, was that in Meigs County?
yes, that was in my house as well.
Count 4, January 22nd, possession of drugs, 1.04 grams of fentanyl. Is that the
Yeah.
first bag we talked about?
Yeah.
And did you possess that bag?
Yes,
Did you do that in Meigs County?
yes,
All right, count 5. So these next couple of counts are from January 27th, okay?
right.
Trafficking in drugs, 0.9 grams of heroin. Did you traffic 0.9 grams of heroin on the 27th?
Yes,
All right, the 27th of January, trafficking in drugs, 0.9 grams of fentanyl.
Count 6.
Okay, sorry, count 6.
Yeah.
Did you, was that the same bag or was that separate?
that would have been a separate instance, a separate bag.
The point, okay,
Oh, the 0.9, yes, yes,
So the
those
point-
are both same bag.
okay,
Yes,
so
I'm
January
sorry.
27th was 1 day, 1 bag?
Yep.
January 22nd was 1 day, 1 bag?
Yes,
So count 6 happened in Meigs County, Ohio, where you trafficked that?
yes,
Okay,
Yeah.
count 7 is for possession of 0.9 grams of heroin. When you traffic the 0.9 grams of heroin, did you possess it?
yes,
That happened in Meigs County.
yes,
Count 8 is January 27th, possession of drugs, fentanyl 0.9 grams. Did you possess the 0.9 grams of fentanyl when you
Yes.
trafficked it?
Yeah.
That was in Meigs County.
yes.
All right.
Yeah, I was, just real quick, Eric, I was pretty bad when I was, what I was doing. I mean, I started in right around the 2025, just to get basically, and I feel terrible for saying this, and I don't mean to get nobody else in trouble. I just saying, it's my own fault. I don't even want to tear up here, but I felt for somebody. And of course, they would say the right words, so I thought everything was okay. And then I didn't like her being sick, which kind of tugged me, so I would give her money.
So sick, like dope sick when she come
Yes,
off.
yeah,
Dope
oh yeah,
sick.
she was like, she got really bad.
Withdrawal.
But that was like chasing. She was like every day, and you could see it on my phone, texting constantly about, can you come get me? Can we go to Galapagos? Can we go to Point? And I even said it, I said, aren't you just getting tired of this chase? Cause it was, I was getting overwhelmed and I wasn't even, at that point, wasn't even really getting into it yet. Then I thought if I would do it, I'd get closer to her, and that's when I started. And yeah, that was a mistake, obviously, in the long run, hindsight. And I'm not trying to make light of it or make a joke. That's the only way I can deal with it sometimes, just I laugh about it. It's like, what can I do? I can't control what I did. It's in the past, it's done.
You can
I
control the
can only
future.
control from this point
Yeah,
forward.
right.
And, yeah, I was doing. I guess I'm telling myself, I don't matter because I'm an honest person like that. I was doing anywhere from 2 to 3 grams a day myself. And for using my car or driving today, I would get either a 1/4 ounce or an 8 ball, which is 3.5 grams. And she would come over and I would give it to her. I mean, usually be half of what I had. I'd always give her just because so she wouldn't be sick. And then she'd call me up one day or text me one day and ask me if I could get her, and I didn't have any. And when he goes, what about Austin? Same his name, but anyways, what about him? I said, well, I can check. And sure enough, I got it for her. And then she'd come over and I gave it to her and she gave me the money. Not realizing this was all, but you know, I mean, shame on me. I shouldn't have been doing it to begin with. So I can't be mad about that. I made peace with it because, you know, if it wasn't for that, I mean, statistically with this fentanyl stuff, how much as I was doing, I'm really surprised I made it. And I got told a statistic, which is crazy. A fentanyl user only has 2 years. That is crazy. I'm sorry. I don't mean to sound, but that is nuts when you think about it. I had a year in it. I mean, so it could have happened. So I'm just grateful things played out the way it did. I mean, it's unfortunate, but and I'm not making excuses for what I did when I say, you know, I did wrong. I was in the right mind. I should have made the right choice and I did. And, you know, I'm sorry for that, but I just know that, you know, being a clearer head now, I almost makes me sick. It made me sick, you talking about it. All the accounts, it really did make me sick to my stomach. I told her I was actually thinking about breakfast, but I don't even know if I can do that now. I just, my nerves are shot. I feel bad about what happened. And
Very
I
serious.
apologize to you for wasting, because to me, this is a waste of time. There's something that should never happen on my part. It's not a waste of time, but you know what I'm trying to say. I'm wasting the court's
I do.
time with
think I
something that I shouldn't have done.
All right.
So
Having explained those things, thank you. Thank you for that. Do you have any questions for me before we proceed?
no, you're not.
Do you need to talk to your attorney anymore before we proceed?
No, you're not.
Have you had enough time to think about this important decision?
Yes, sir.
Are you certain this is what you want to do?
Yes, sir.
When you came in for the first time in front of me after you were indicted, I entered a not guilty plea on your behalf. Before I can accept anything different than not guilty, you first would have to withdraw the not guilty pleas. At this time, do you want to withdraw the not guilty pleas as to all the counts in case number 26CR020?
Yes, Your Honor.
And do you want to withdraw all the not guilty pleas in case for each count in case number 26CR041?
Yes, Your Honor.
Now, specifically going back through case number 26CR020, what is your plea now to count 1, possession of drugs, a felony, the 4th degree?
Guilty.
What now is your plea to count 2, possession of drugs, a felony, the 4th degree?
Guilty, Your Honor.
What is your plea now to count 3, possession of drugs, a felony, the 5th degree?
Guilty, Your Honor.
What is your plea now to count 4, possession of drugs, a felony, the 5th degree?
Guilty, Your Honor.
What's your plea now to count 5, trafficking in drugs, a felony, the 5th degree?
Guilty, Your Honor.
What's your plea now to count 6, trafficking drugs, a felony, the 4th degree?
Guilty, Your Honor.
What is your plea now to count 7, trafficking drugs, a felony, the 5th degree?
Guilty.
And was your plea now to count 8, trafficking drugs, a felony, the 4th degree?
Guilty, Your Honor.
Okay, and moving on now to case number 26CR041. What is your plea now to count 1, trafficking in drugs, a felony, the 4th degree?
Guilty, Your Honor.
What's your plea now to count 2, trafficking in drugs, a felony, the 4th degree?
Guilty, Your Honor.
What's your plea now to count 3, possession of drugs, a felony, the 4th degree?
Guilty.
What's your plea now to count 4, possession of drugs, a felony, the 4th degree?
Guilty.
What's your plea now to count 5, trafficking in drugs, a felony, the 5th degree?
Guilty, Your Honor.
What's your plea now to count 6, trafficking in drugs, a felony, the 5th degree?
Guilty, Your Honor.
What's your plea now to count 7, possession of drugs, a felony, the 5th degree?
Guilty, Your Honor.
What's your plea now to possession of drugs, a felony of the 5th degree?
Guilty.
I have in front of me written pleas of guilty in both cases. So again, back to 26 CR 020 on page 4. Our signatures under the written plea of guilty. Does that contain your signature?
Yes, yes, sir.
The following page has a signature and it's for the waiver of jury trial acknowledgement of rights. Does it likewise have your signature?
Yes, Your Honor.
Okay, now moving on to case number 26 CR 041. Also a written plea of guilty on page 4 appears some signatures. Does that include your
Yes, Your
signature?
Honor.
In the following page, a waiver of jury trial acknowledgement of rights. Likewise have some signatures. Does that include your signature?
Yes, Your Honor.
Did you sign the written pleas of guilty and the waiver of jury trial and acknowledgement of rights in each of these cases knowingly,
Yes, Your Honor.
intelligently,
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Therefore, let the record reflect the defendant has made a knowing, intelligent, and voluntary decision to withdraw his previous plea of not guilty and now tender a plea of guilty in case number 26 CR 020 to count 1, possession of drugs, a felony of the 4th degree, to count 2, possession of drugs, a felony of the 4th degree, to count 3, possession of drugs, a felony of the 5th degree, to count 4, possession of drugs, a felony of the 5th degree, to count 5, trafficking in drugs, a felony of the 5th degree, to count 6, trafficking in drugs, a felony of the 4th degree, to count 7, trafficking in drugs, a felony of the 5th degree, and to count 8, trafficking in drugs, a felony of the 4th degree. And in case number 26 CR 041, he's pled guilty to trafficking in count 1, trafficking in drugs, a felony of the 4th degree, count 2, trafficking drugs, a felony of the 4th degree, count 3, possession of drugs, a felony of the 4th degree, count 4, possession of drugs, a felony of the 4th degree, count 5, trafficking in drugs, a felony of the 5th degree, count 6, trafficking in drugs, a felony of the 5th degree, count 7, possession of drugs, a felony of the 5th degree, and count 8, possession of drugs, a felony of the 5th degree. The court specifically finds the defendant has been informed of all of his constitutional rights, that he understands the nature of the charges and the effects of the pleas of guilty, as well as the possible penalties that could be imposed. Therefore, the court accepts the defendant's pleas of guilty and finds him guilty in case number 26 CR 020 to count 1, possession of drugs, a felony of the 4th degree in violation of Ohio Revised Code section 2925.11a, and finds him guilty of count 2, possession of drugs, a felony of the 4th degree in violation of Ohio Revised Code section 2925.11a, and finds him guilty in count 3, possession of drugs, a felony of the 5th degree in violation of Ohio Revised Code section 2925.11a. You need to be muted, people. Okay, so I'm repeating, will find that, you guilty of count 3, possession of drugs, a felony of the 5th degree in violation of Ohio Revised Code section 2925.11a, finds you guilty of count 4, possession of drugs, a felony in the 5th degree in violation of Ohio Revised Code section 2925.11a, find you guilty of count 5, trafficking in drugs, a felony in the 5th degree violation of Ohio Revised Code section 2925.03a2, and find you guilty of trafficking drugs in count 6, a felony to 4th degree in violation of Ohio Revised Code section 2925.03a2, and find you guilty in count 7, trafficking drugs, felony to 5th degree in violation of Ohio Revised Code section 2925.03a2, and find you guilty in count 8, trafficking drugs, a felony to 4th degree in violation of Ohio Revised Code section 2925.03a2, and in case number 26 CR 041, I specifically find you guilty of count 1, trafficking drugs, a felony of 4th degree in violation of Ohio Revised Code section 2925.03a1, and finds you guilty of count 2, trafficking drugs, a felony of the 4th degree in violation of Ohio Revised Code section 2925.03a1, finds you guilty in count 3, of possession of drugs, a felony of the 4th degree in violation of Ohio Revised Code section 2925.11a, and finds you guilty in count 4, possession of drugs, a felony of the 4th degree in violation of Ohio Revised Code section 2925.11a, finds you guilty in count 5, trafficking drugs, a felony, the 5th degree in violation of Ohio Revised Code section 2925.03a1, finds you guilty in count 6, trafficking of drugs, a felony, the 5th degree in violation of Ohio Revised Code section 2925.03a1, and finds you guilty in count 7, possession of drugs, a felony, the 5th degree in violation of Ohio Revised Code section 2925.11a, and find you guilty in count 8, possession of drugs, a felony, the 5th degree in violation of Ohio Revised Code section 2925.11a. And what time is it? Do you need to get on her? Can I go ahead and sentence them?
Okay.
Which way?
You can send it them.
Okay.
It's not till 11.
Okay, so with those specific findings, the court is prepared to proceed to sentencing. Is the state prepared to proceed to sentencing?
Yes, Your Honor.
Defense counsel?
Wait, yes,
Mr. Barnes, do you have anything to say regarding why the sentencing hearing should not proceed?
No, Your Honor.
Prosecution position again for sentencing?
Yes, Your Honor. The state would ask that the court go on the agreement of the parties, which is in case number 26CR020, that upon the defendant's pleas to counts 1 through 8 of the indictment, the defendant shall be sentenced to community control, and as a condition of that community control, complete inpatient treatment at steps to recovery. And further, the defendant would agree to forfeit a Marlin 3030 serial number 260102243. A Marlin 39A22 serial number 2715590. And an H&R Sportsman 22 serial number 512506 to the Meigs County Sheriff's Office and be assessed the court costs in this matter. And in case number 26CR041, upon the defendant's pleas counts 1 through 8 of the indictment, with the sentence to community control, and as a condition of that community control, successfully complete inpatient rehab at steps of recovery, and also be assessed the court costs in this matter.
Thank you. And there's no individual victims, so defense counsel?
Yes, Your Honor, I think that my client had a tremendous statement, as I previously said. I think that these one super clients that I have right now, I think that these people do a tremendous job now. So it just has to be something that requires.
All right. Mr. Barnes, do you have anything else you want to say on your own behalf or to present any information and mitigation of punishment?
No, Your Honor.
Okay, no, I'll accept what you said before that would really kind of fit here as well, so I appreciate that.
Thank you.
The court must consider certain things before imposing sentence, one of which would be that pre-sentence investigation report, but as was noted when we started sentencing, it has been waived by all necessary parties. The court has considered the Rule 11F statements, which show the plea negotiation, the sworn testimony, the record, and other relevant information. The court has formulated its decision based upon the 3 overriding principles and purposes of felony sentencing, which are to protect the public from future crimes by the defendant or others, to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanctions the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitating the offender, deterring the offender, rehabilitating the offender, and providing for restitution. The court has also made sure the sentence is not based upon any impermissible purpose. The sentence is consistent with other similar offenses committed by like offenders. The sentence is proportional to the harm caused and impact upon the victim, in this case, the victim being the state of Ohio. The court has also considered any seriousness or recidivism factors which may be applicable, and the fact that all counts and all indictments are felonies of the 4th or 5th degree, which carry a presumption in favor of community control. With those considerations, the court finds that a prison term is not consistent with the purposes and principles of felony sentencing. As part of your sentence, community control sanctions are being imposed for a period of 5 years. If you violate the terms of your community control sanctions, violate the law, or leave the state without permission of your probation officer, the court may extend the period of supervision, impose more restrictive sanctions, or may impose prison term for all the counts that are count 5s of up to 6, 7, 8, 9, 10, 11, or 12 months in prison, up to $2,500. All the counts that are count 4s, you may be sentenced, and that sentence is reserved of anywhere from 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months, a fine of up to $5,000. Or both. The special conditions of your community control beyond the standard conditions are that you must remain in and successfully complete your inpatient treatment at steps of recovery and sign all releases necessary so the probation gets the weekly reports on your progress and gets proof that you successfully completed the program. Also, in case number 26CR020, the court finds and orders the forfeiture of the Marlin 3030, the Marlin 39A22, and the H&R Sportsman 22 serial numbers having previously been read to the Meigs County Sheriff's Office, and orders you to pay the court costs in that case as well. Likewise, in case number 28CR041, the court sentences you to that community control, but it's again reserving the sentences that if you would violate terms and conditions, all the felony fours again to anywhere from 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or up to 18 months. And the felony fives anywhere from 6, 7, 8, 9, 10, 11, 12. Or 12 months, fine of up to $2,500 or both. Of course, the felony fours are fine of up to $500 or both. If your violations, however, are technical, you would be limited on the felony fives. If there's a probation violation of up to 90 days, and on the felonies, it's fourth degree, a violation of up to 180 days of local incarceration. If they're technical or a misdemeanor violation. But because all this jail time is being suspended, I do need to remind you that if you violate the terms and conditions of community control, you'll end up going to prison. And if you go to prison, you may be subject to up to 2 years of post-release control under Revised Code Section 2967.28. If or when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You will have to pay the court costs in both cases, and you'll get credit for any time served if you were incarcerated during any time for these 2 cases. You have the right to appeal this court's decision, and the appeal must be made within 30 days after you're sentenced, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No, you're not.
So I do need to tell you, you need to keep in touch with your probation department. And I think maybe you already know them from some pretrial. Do they have, I'll have you check in with them today, make sure they have
Okay.
everything you need. And within 48 hours of completing everything at your current inpatients, you must come in person to meet with them within 48 hours. You know, just sit here, push the kiosk and wait your turn, and then they'll get you on a reporting schedule from that time. But make sure you do
Okay.
report in person within 48 hours.
Okay.
Okay, do you have any questions?
No, Your Honor.
Anything from defense counsel?
Nothing further.
Or anything from the state?
No, Your Honor. Thank you.
All right, then good luck to you. It sounds like you're on the right track, and I'm happy for you that
Thank you
you've
so
been able
much.
to do that.
Yeah.
And I'll get out of the way so you can work with Judge Wallace here. And then we had another change of plea, don't we?
Yes.
Yeah.
They just sent it.
Okay, so we'll let Judge Wallace have the floor though. And I'll step away, and then we'll do that other case later.
All rise, please.
Well, let's wait.
That's the only thing you
All
have.
right, here, please.
Alright, Shaver for Shaver.
I just need this turned up.
Yes. You did, yes.
Okay, good.
Mhm.
I see Judge Wallace. I can't hear him though. Come here, stay right there.
Brent Saunders, can you hear me?
There we are. Hi, Brent. Can you hear me?
I can.
Okay, good.
Rob here. Can you
There
all
we
hear?
go. All right, everybody should be able to hear me. All right, and so at this point, I gather Bob Toy, you're representing Mrs. Schaefer.
That's correct.
All right. Okay, I'll change my little note here. There we go. All right, this case has been going on forever. And so, as far as I'm concerned, we're just gonna set it for trial and try it.
I think that's what you probably have to do. I've asked for, I have, Judge,
Yeah.
retained a firm to do a forensic investigation.
Mm-hmm.
Perry and Associates. I've sent
Okay.
subpoenas to TransUnion, Equifax, Experian, dealing with his credit report. I
Mm-hmm.
received yesterday afternoon from a CPA just information about their prior filings.
Mm-hmm.
So I need some time before trial.
Okay.
I just got in this a month ago, but the allegations are that he is not providing us with information. He's hiding information from us and hiding assets. So that's the issue that we have in front of us today. So I've got a forensic accounting firm that we've paid a lot of money to do the investigation.
Okay, and hopefully if we have a trial, which it looked like we're gonna have, they're gonna show up and testify.
They will.
Okay, good. All right. All right, Mr. Saunders, do you think we're just ready to try this?
Yes, Your Honor, and I'll be happy to work with Mr. Toy on anything he wants. I've not heard from Mr. Toy yet, but if there's anything he thinks that he hasn't received, all he needs to do is pick up the phone and call me, and we'll get him anything he wants.
All right, that's good, Brent. Nice seeing you again.
Nice seeing you, sir.
All right.
All right, now, if this goes to trial, which it sounds like it's going to, how long is the trial gonna last?
I'd say 2 days, Judge.
2 days? Do you agree with that, Mr. Saunders?
Yes, sir, Your Honor.
Okay. And, okay, if we have this trial, obviously it'll be to me. Please define your terms as you go with the testimony here. Don't leave me just with a bunch of shortcuts on, for example, if you use Ohio University Credit Union, you can say OU-CU, but please define what it is. I know what it is, but the record is the record. Okay.
Got it.
Example. Just don't throw a whole huge pile of documents at me and say, well, you kind of just figure it out. I don't appreciate that. If you're going to provide me with a big pile of documents, please provide me with some context too. All right. And if there's something in that pile of documents that is really significant, instead of just putting it in the pile of documents and hoping and expecting, as I leaf my way through several hundred pieces of paper, I will see that piece of paper and I'll attach great significance to it. Introduce that separately, perhaps. All right. And also, if you're going to stipulate some things, and I would encourage you to do that, please stipulate in writing. I realize that there may be some last minute stipulations, but if you can give me stipulations in writing, it helps. Okay. So 2 days, when do we think we can be ready to try this thing?
October would be the earliest, Judge.
Okay. Let's see.
I don't know if we're going to be fine time on the schedule. Let me get my book in here past that time. Just one
Sure.
second. Hold on.
Yeah.
Judge, this is Brent Saunders.
Sure.
Bring in the book,
I
please.
just got back from vacation and my secretary is going. I do have my calendar on the phone, but I'm also trying to do this Zoom on the phone so I can
Okay.
my calendar without disconnecting.
Okay.
I apologize.
That's okay.
Good.
Yeah, we can do it sometime in October, or we can do it perhaps sometime in November. I'm busy the first week of November, but after
I
that,
could do first week, yeah.
first week of November.
Yeah, that would be good with me. Take a look here.
I can't do it the first week of November. I can do it. I can do it second week. That is clear. Every day, of course, we have Veterans Day in the middle of it. So, but the 9th or the 10th or the 12th or the 13th is fine, unless you want to work on Veterans Day. I'm a veteran, but I don't really care. I want to get this done. The court employees may feel differently about that.
Judge, I have a daughter getting married in November, and I'm out for a week and a half beginning November 9th.
Okay.
Until and I'm looking at it.
Mm-hmm.
Okay. Till the 21st, I believe. November. No, till the 24th.
Okay.
So yeah, I'm gone for almost 2 weeks.
Yeah, I see that. And then we have Thanksgiving, obviously.
Yeah, and then we have Thanksgiving. So I have I am, you get me a date in October or November. I know you're gone the first week of November. I don't want to move it to December, but I can if necessary.
maybe we'll just look
October-
at starting it on November 30th if there's a date available and
I could do that.
finishing it up on December 1st.
That's fine.
Now that would be the first couple of days of deer season. We don't have any deer hunters in this, do we?
No,
No? Okay.
they could use my land to hunt though. They're
Okay.
all over.
All right. Um,
Oh,
Mr. Saunders, how does that sound to you?
I think we lost him.
Oh, well, that's not good.
Can you hear me now?
Oh, there we go.
Yes. we can.
The 30th and the 1st are fine, Judge.
Okay.
Excellent.
Is that fine with the court?
Yeah, we're available.
Okay, so we'll set it for the 30th of November and the 1st of December.
What time do you want to start?
Probably 9 o'clock,
Okay,
both days.
that'll work.
Okay, sounds like a winner. This is
All right.
Meigs. Okay. Yeah, and hopefully I'll give you enough time to do whatever you need to do with your forensic accountant.
That's good. Yeah. All right. I appreciate it, Judge. Thank you.
Bob, I'll get with you and maybe I can shortcut a lot of that for you, but we'll go.
That's good. I'll get a hold of you. I'm just waiting for this information before I contacted you, and I just got in the stuff yesterday. So
Not
I'll
a
give you
problem.
a call. All right.
Thank you, Judge.
Thank you,
Okay,
Judge.
Thank you.
Take care.
All
Bye-bye.
right, bye-bye. All right. So somebody that's still there from the court?
Yeah,
Okay, yeah, if you can get out a notice, that'd be great.
yeah, I'll do something.
Okay, great.
I'll send it to you first.
Yeah, that sounds like a plan.
Okay, thanks.
All right, thank you.
Okay, bye.
Bye-bye.
because I failed to turn that on. So we are on the record. Again, I'll just gonna say State versus Hergott, 26 CR 012 and 25 CR 100. Mr. Scott Hergott's present with his attorney Scott Petroff, and Sidney Whitey's representing State. That there was verification that victim was notified. Whether the victim wants to be present is being inquired about at this time. She's just
I
double
do
check.
not believe the victim wants to be present.
You don't believe what? Does not think the victim will be present? Is that what she said?
Yes.
Okay, that's fine then. All right, we are here because we were scheduled for a status hearing because we have an upcoming jury trial. So is everybody ready to go to jury trial? Ready to proceed?
At this time, we would be asking for a continuance. There's, for a couple of reasons. The last time we were here, there were some discovery issues that we've worked out. Mr. Hergott and I recently had a jail visit that was very productive. We worked out what our strategy going forward is going to be. Shifted some things that we're going to do. So I had a conversation with Mr. Stanley today about some evidentiary issues. There's two separate cases, so there's evidentiary issues in both cases. We came to more or less agreement on some of those issues, but he wanted some time to look into some things to determine whether or not they needed to file a motion one day. I'm aware also that the state has a trial that's beginning next week, so this is currently set for August 11th. Given the serious nature of the allegations here, very serious sentence my client's facing, I think it would be appropriate to have some additional time to work through some of those issues that we've been working through. Mr. Hergott and I have discussed the need to execute a waiver of speedy trial. I have that document here prepared to execute that on the record today.
Okay, State's response to the request to continue the jury trial.
I just found the state would not opposed to be plus to continue.
Okay, then if you can go through the waiver of speedy trial with him on the record.
Yes, sure. So Scott, we have discussed our trial strategy and the fact that we're gonna ask for the trial date. You know that? Okay, so you have a constitutional speedy trial right and you have a statutory speedy trial right, okay? With the statutory speedy trial right, they'd have to bring in the trial within 270 days. But we're asking to pause that clock so that we can work through some of the issues that you and I have discussed. Do you remember that? Yes. Okay, are you okay with waiving that speedy trial right until then we're gonna set in the trial date? Yes. Okay. So you'll execute that over here. Today's date is July 22nd.
Do you have any questions for me?
I do not.
Okay, we will schedule a new status date and a jury trial date because I want to make sure we have one less effort to see if it's resolved or at least make sure.
As the witness.
Yes. Want to make sure everything's uploaded to Case Center and operable and the jury instructions and such are ready. You can just give it to her. So let's get a status date and a jury trial date.
What about September 1st for a jury trial? Or do you want longer?
We get a little bit longer.
September 22nd?
That works for me.
Or the 29th,
Um,
because the prosecutors are out the 24th, 25th.
I've got hanging set for the 29th, but I can't imagine. we can
oh,
go that
there's
quick.
no way it could go that quick.
So I'm okay with putting it on the 29th.
29th, you said that,
September 29th.
I thought you said 22nd, but you've changed it to 29th. Okay.
Well, the prosecutors are out the 24th, 25th.
First case, I don't imagine it's gonna be 3 days, but just in case, I think 29th would be safe.
Okay.
How about September 15th at 1:30?
That works. I'm hard to get out there.
15th at what time?
1:30.
1:30 on the 15th. Those dates will all be on the entry that says what happened here today. So those dates will be provided to you in the paperwork from today's hearing. Okay. Anything else from the state
No.
or defense counsel?
Nothing further from.
Oh, okay,
Sure, thank you.
thanks. We're ready then, if you can go switch and have Mr. Klein brought out.
Who would you like, Judge?
Mr. Klein and Ms. Bunce. Thank you. He has 3 cases, right? 4, okay, I've got 22, 163, 21, 126, 19, 142, and what's the other one?
21, 120, for that,
Yeah, I did that one.
20, 156.
156 is the one I didn't have. Ready whenever you get the record on. We are on the record of the Meigs County Common Pleas Court in State versus Klein, 22 CR 163, 21 CR 126, 19 CR 142, and 21 CR 156. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name. What's your inmate number?
55739,
And you're in which institution?
Noble Corrections.
Noble. And your attorney.
Yes, I'm Denise Buns here on behalf of Mr. Klein.
Thank you. And for the state?
Yes, Your Honor, Abigail Gilkey, Assistant Prosecuting Attorney, Meigs County, Ohio, along with Sidney Whiting, Assistant Prosecuting Attorney, Nonetheless.
And there would be a victim or victims in at least some of the cases. Were they notified of today's proceedings?
Yes, Your Honor.
And are any of them present?
No, Your Honor.
Are they anticipated to be present?
No, Your Honor.
Hey, you're shaking your head. Are some of them present?
Oh, no.
I thought you were saying they were in the hallway or something. So you're good to proceed.
Yes, Your Honor.
With that, then, we have, the motion to revoke community control filed, and then I know there's some memorandums, and contras that in the event that he's found to have violated terms and conditions of his community control, asking for certain credits to be given or not to be given, depending on which side you're arguing. So with that, we'll start with the probable cause hearing, unless there's an agreement to admit.
There is not.
Okay, so with that, is there any agreement on anything?
No.
Okay, it's fine then. Call, state, call your first witness.
State would call Cassie Wilson.
If you would, please come up, raise your right hand.
Yes, ma'am.
Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Have a seat and state your name and occupational address.
Name is Cassidy Wilford. Work at 100 East Second Street, Pomeroy, Ohio, for the Meigs Common Pleas Court. I'm the chief probation officer.
Your witness.
Can you please describe your duties as the chief probation officer?
Yes, so as our probation department is split, I have a female officer that handles the female caseload, and I handle the male caseload placed on community control through the Common Pleas Court.
And as a part of your duties as the chief probation officer, did you become familiar with the David J. Klein?
Yes, I was. He was sentenced on February 22nd, 2023. the 5 years community control with a special condition that he successfully enter into and complete the STAR Community Justice Program. After the sentencing hearing that day, he was released to then check himself in to the Meigs County Sheriff's Office on February 26, 2023, for a mandatory 3-day hold before he was picked up from STAR on March 1st, 2023. Mr. Klein failed to do that, did not check himself in to the Meigs County Sheriff's Office on February 26, 2023.
Did you have any communication with Mr. Klein after the failure to check in?
No, all attempts failed. Tried to reach him by phone, never was able to reach Mr. Klein.
Are you aware of if he ever did turn himself into a?
No, he did not.
And do you recall, is it a part of the agreement that he would go to STAR? And if he did not, that it would be considered a violation of his community?
Yes, it clearly states inside of the judgment entry from this court that he had to successfully enter into and complete the STAR Community Justice Program.
And to your knowledge, he hasn't done.
That is correct.
No further questions.
Okay, Cross.
Yes, Your Honor. So, with respect to the probation, requirements, I know Mr. Klein was expected to go to report in for the STAR program. Do you know if there would have been any reason that would prevent him from being able to report in, say he was sick in the hospital?
There was no communications to me.
No communications, okay. And did you attempt to make any communications with him?
I did. On February 26th, when he filed the report, I made a phone call to the number we had on file.
Okay, what was the result of that phone call?
I did not receive an answer.
Okay, so you left a message, is that what you mean?
I can't recall if I left a voicemail or a message. In my notes, I attempted a phone call, and the calls failed. No, I didn't reach anyone.
Okay. So, and I don't know if this is normally something you would do. Did you check to see if, say, he had been in any other, your jurisdictions, like say in jail or anything like that?
In 2023?
Yes, ma'am. Or sorry.
No,
Okay.
no, because
All right.
once I got word from the sheriff's office that he did not turn himself in, he wasn't in our jurisdiction.
Okay. So, oh, you had checked with the sheriff's.
That's how I knew he
department.
didn't turn himself in on February
Okay,
26th.
I get it. And they would have told you if he was in jail for anything for
Correct.
them. Okay, I get you. So and do you think they would have probably told you if he was in jail for any other local jurisdiction in the state of Ohio?
No, I can't say that, no.
Okay,
He was not in the Meigs County Sheriff's Officer custody at that time like he was supposed to be.
all right. And I have a question with respect to, Mr. Klein. I mean, I guess it's pretty obvious that he's, in prison now, and he was picked up. And I don't know if you are aware of the fact that he would have been picked up in Washington County on this warrant.
On this warrant?
Yes.
No, I am unaware of him being picked up for the Meigs County warrant. I am aware that he was picked up for Washington County due to new charges in Washington County, but I'm not aware of picked up on this warrant.
Okay, so you don't have any information
No,
about that, and no one ever contacted you
no, ma'am.
saying, hey, Mr. Klein's here in our Washington County.
No one
Sheriff's
contacted me,
Department.
no, ma'am.
Okay. And is that probably the normal scheme of things that?
I do not normally get contacted, no.
Okay.
They wouldn't have known that he was on my caseload.
Okay,
So-
so if say Meigs County were to be notified of someone being arrested somewhere else, they don't share that information with you?
If Meigs County was notified,
Yeah, Meigs County Sheriff's
Oh, the
Department.
sheriff's
no.
office.
the sheriff's office, yes, normally the sheriff's office would have tell me, hey, we put a holder on such and such as in such and such county custody, but that was not the case in this instance.
Okay.
I was not notified for anything.
Thank you. I have nothing further.
Any redirect?
No, Your Honor.
Okay, thank you very much. Next witness?
State arrest.
Any defense witnesses?
No, I don't.
Find that he violated terms and conditions of community control and the court's prepared to proceed to the sanction or adjudication. Is the state prepared to proceed?
Yes, Your Honor.
Is defense counsel?
Yes.
Is any reason from defendant's perspective why we can't move to that stage of the proceedings today?
Yes.
No. Okay, with that then, state's argument on what's appropriate sanction.
Yes, Your Honor. The state would ask that the defendant be sentenced to his maximum time over his head, which is 90 months on each charge. And the state.
90 months on each
or,
charge?
I'm sorry,
Okay,
with
let's
each
break it down.
charge.
Okay,
Yes. So there's 36 months on one charge, 36 months on another. I think it's 18 on tops.
well, there's 4 cases. So let's talk about which cases and which case numbers.
Sorry, Your Honor, just a moment.
Sure.
Yeah, state just want to brief research. It's a few minutes.
Okay, go ahead. Oh. Yeah, because I'd like it broken down, is what I'm asking
Okay.
for each case. You haven't heard any more about that domestic violence case that's supposed to start at 1.
Lindsay just asked this morning if we had a case that I told her I didn't think so.
Oh, we could do it. Oh,
Oh,
she's
wow.
probably already, I can look and see, she may have.
Yeah. That's too late. But I haven't heard anything from anybody else.
And she represents petitioner or respondent. Respondent, right?
I don't remember.
Well, I think it was the petitioner that asked for the continuance of it.
Yes, that's right. So she's.
There's nothing on Google. Wonder, did you have Jim set up case center?
I doubt it, because I don't even know we've been to any hearing. And what's the thing just got on the case? This week's or end of last.
Your Honor, the state very long.
All right, are we on?
Now,
Hey, we are back on record, so after a brief recess, go ahead.
Thank you for that time. I had notes, I just couldn't locate them. So the state is actually asking for a total of 108 months in case number 19 CR 142. There's,
What's 19 CR 142?
yes,
Okay,
there are 2 convictions for felony for receiving stolen property. So the state's asking for 18 months on each of those. In 20 CR 156, those were admitted to misdemeanors, so the state's not asking for any time on that.
and which case number is that?
20
20.
CR 156.
Produced.
And then case number 21 CR 126. There's a conviction for a felony 3 bribery. State's asking for 36 months on that. And then in case number 22 CR 163. There's a felony 3 tampering. The state's asking for 36 months on that as well, for a total of 108 months.
And do you want to, I know Ms. Bunce is going to argue that he should have some credit, already towards whatever I end up sentencing him to. Do you want to address that now, or do you want to address that after we argue about what the appropriate sentence would be?
Whichever the court would.
Let's go ahead and argue about the appropriate sentence. So the state is requesting that he serve all suspended time consecutively. I assume that's what you're saying, for it to be
Yes,
able to be 108 months. So then defense,
Yes, Your Honor. And I guess we're not, since the victims aren't here or whatever, I just wanted to make sure.
oh yeah, are there any victim impacts coming in from the state or anybody?
No.
Okay,
Okay.
thank you.
We just know that's the next.
That is the
step, and
next
I didn't
step.
want to
Thank
not
you.
do
That's
that
fine.
part.
Thank you.
Okay, so with respect to the sentencing part of the whole business, essentially, I think my client is more of a mind that we deal with the issues of more like the minimums. So with respect to 19 CR 142, I think he would request the court look at more in terms of 9 months, which is the minimum.
No,
with
9 months on that would be, or minimum on 19-0142, and F4
Oh, it's sorry.
would be 6 months, but
6
I
months.
mean, just that is the
Did
minimum.
I have it written down on, sorry.
Well, if it's an F4, and that's what I
Oh,
understand.
Yeah, times 2. You're right, 6 months. And I guess I would ask that those would merge, Your Honor.
But they don't
Um,
merge, or yes,
Oh, I'm right. You're right. You're right. It's not a merger, but we would essentially ask that they be.
okay,
I apologize.
that's all right.
All right, so yes, for the 19 CR 142, there are 2 F4s. We would ask that those 2 F4s be 6 months and that they be run concurrently. We would also ask with respect to 20 CR 156, the receiving stolen property, which is an F4, 6 months. We would also ask for 21 CR 126, which is an F3. And we would ask for the minimum on that, which is the 9 months. And for the 22 CR 163, which is another F3, would also ask for 9 months. And so the situation we have is that I know that there's a lot of time any way you slice it with us having 4 cases. And my client already is serving in a lengthy sentence for another county. And I don't think that he wants to be burdened with additional lengthy time from here. He has spent majority of the time in the last 1.5 years, either in jail or in prison. And of course, we do want to get to the issue of what kind of credit he should get for the time. And I know that that may be our next step with respect to all this.
Okay,
From what I
and
understand, I think you were saying you wanted to hear our arguments with respect to the amount of time first.
okay,
And so we're asking essentially, Your Honor, that the court give my client the minimum sentence. He's already got some time that he's serving, as I said, for this other case in Washington County. And he would like to, I think, still be allowed to have a life once all this is done. And the longer the sentence, the less likely he is to be able to come out of this and actually have the chance at a productive life. And I guess too, with respect to that, we would ask the court to consider, since we can make our asks here, we'll ask that also the court consider the possibility of making that sentence concurrent with the other sentence that he has in Washington County. I know that he's really going to be needing all the help that he can get in terms of trying to move on with his life. And I think that that would probably be the best chance that he would get at that, if the court's not tacking on to the lengthy sentence that he's already got. And So I think that he has plenty that I think he'd like to say. I don't know if it's so much on this part of it, but I would like to have him have an opportunity. He's pretty well spoken and is very thoughtful, and has plenty of ideas about what should happen. And so I'd like to also give him that opportunity.
All right. With regards to what the appropriate sanction would be, I will, of course, give Mr. Klein an opportunity. Do you have anything to say on your own behalf or to present any information and mitigation of punishment? Sure.
Your Honor, I think I may have misspoken. I spoke with my client just now. And I think his main concern with all of this of saying that he gets any sentence at all fails to consider the issue of his due process rights. Mr. Klein feels that his due process rights were severely violated by him remaining in jail since February 28th of last year. And the sheriff's department in our county being notified about him being in jail and saying they were going to pick him up. That didn't happen. Once again, at the end of June, there was notification sent. I can't talk. Notification was sent to the Meigs County Sheriff's Department, and nothing ever happened yet again. The only reason that Mr. Klein is even here today is because Mr. Klein filed a motion. Otherwise, he would probably serve his entire sentence for Washington County, and then Meigs County would be notified and maybe pick him up and do something years later. And so Mr. Klein feels that his rights were violated to the extent that he feels that the sentencing should not go forward, and that his rights should be considered in having not been treated properly. Just because he was in jail doesn't mean that he's still not entitled to be heard and to be given the right to a bond, whatever, through this probation violation. Well, the multiple probation violations that are here before this court today that were not done until he actually made the effort to have the court hear it. And he is thankful, of course, that the court has heard it and he is here today. But there's been a very egregious, I guess, violation of his due process rights that he would like to speak on.
Okay, with that then, if you want to make a statement.
Thank you, Your Honor. I was arrested on February 28th of 25. And on February 28th of 25, 508, a John Archer of Washington County Criminal Division Department made contact with Lieutenant Brandon King, which I do have proof of, stating that I was there. And that triggers criminal 4, which means there's a pretty distinct time frame of picking me up and making those arrangements. However, she notified John Archer back, which I do have copies of, and making the arrangements to pick me up the following Monday or Tuesday of the following week, which would have been March 3rd, I believe, and nothing happened. I was not made note of the warrants until I left for the CRC, but upon further review of digging into this, I've come up with conclusions that, in all honesty, the state failed to act. They never came and got me, never brought me to face up to these charges until I made notification of it this year. Trying to get disposition of it, trying to move forward with my life. However, all this information is surfaced, and under the 14th Amendment to the United States Constitution, And under Ohio Constitution, Article 1, Section 16, in regards to Morrissey versus Brewer and Gagnon versus Scarpelli, violations have definitely occurred. So I appreciate it if the court could look into that. Take into consideration. Thank you.
All right. Anything else with regards to what the appropriate sanction or consequences for the violation should be before we talk about whether there's a. Okay, so I'm not going to dismiss these motions to revoke, and in fact, Mr. Klein has been given, frankly, chance after chance after chance, with 4 indictments in a relatively close period of time, without any prison sentence on 2 felony 3s and 2 felony 4s. I understand one case was reduced to misdemeanor, and that's merged with whatever I do. I think he was given lots of opportunities, and then even when we were on probation violation number whatever, he was given the opportunity to go to STAR, and he knew he didn't go to STAR, so he knew there he had to know there was a warrant out for him when he didn't show up to go to STAR. So I'm going to sentence to the 108 months. Now we can argue about what. So denying the motion to dismiss on the arguments about due process, sentence to 108 months. Which is credit for time served, and then we'll argue about whether or not there should be any credit from an earlier date, earlier than today, earlier than any date. Or I think that Ms. Bunce had filed for the motion, so we'll have her go first.
Thank you, Your Honor. So as I think Mr. Klein had referred to, the situation is that he was picked up back in February of last year, February 28th. The Washington County Sheriff's Department notified our county Sheriff's Department about Mr. Klein being in their jail based on the warrant that Meigs County had.
And do you have some evidence of that fact? I know there's some things attached that I'll probably hear about, so I know there's at least some communication that I saw.
Yes, and that's what we're basing it
Okay,
on.
okay, is there, I don't know if there's anything beyond those attachments.
No.
Okay, that's fine.
No,
Go ahead.
and that's actually evidence that I wouldn't have necessarily had, but for the fact, I mean, I guess I could have subpoenaed
Sure.
it if I had realized that it was there. Or sometimes knowing what's there, sometimes you can't ask for something if you don't know it exists. And I think that's a position that Mr. Klein has been in, and myself as well, that we're kind of at the mercy of what we've been allowed to receive. If we know it's there, we can ask for it, but if we don't know it's there, we can't become aware of it until later on. That being said, yes, there is proof of some communication between the sheriff's departments to pick up Mr. Klein, and the notification indicates that the Meigs County Sheriff's Department would pick Mr. Klein up. He was picked up on a Friday, February 28th, and he was supposed to be picked up by that Monday, which would have been in March, I believe March 3rd, if I'm correct. And with that being said, nothing happened, and he remained in the jail. And once again, there's some information that at the end of June, the Washington County Sheriff's Department again made the Meigs County Sheriff's Department aware of the fact that Mr. Klein was in their jail, and that Meigs County had a warrant and needed to deal with it. And so Mr. Klein believes that he should be given credit for the time from that point of March 3rd of last year, because of that being the time, well, I guess technically even back to February 28th, because he was being held in Washington County, and Washington County notified Meigs County. And as he had indicated, that he was held without any bond, he was awaiting somebody to pick him up from Meigs County. I think it was a lapse. I'm sure it wasn't intentional, but nonetheless, that doesn't mean that it shouldn't count and be credited towards my client. he's essentially, Your Honor, wanting what he believes he's entitled to. He's not asking for anything special. He's not asking for the moon. He's not asking for something beyond what his own rights are, which is that he's in jail in Meigs County because of Meigs County's warrant, then he should be given that credit. And I think if you look at the briefs, both of them are gonna say the same kind of thing in essence, which is if somebody's being held, they gotta be given credit. And that's what we're asking about. And I think that does go to what Mr. Klein said earlier with respect to his due process rights. That's part of what our whole constitutional, whether it be state or federal court, that's what our system is based on, is giving people the right to have their opportunity to be heard in court. Now, that doesn't mean they're always gonna get what they want, doesn't mean they're gonna like it. I mean, I don't know that Mr. Klein's probably very happy with what's happened so far, but at least he's been given an opportunity to be heard. And if the sheriff's department doesn't work to try and bring people in so they can be heard, whether it's on purpose or accidental, and like I said, I'm not saying it's on purpose, but even with it being accidental, Mr. Klein's the one that's still bearing the burden because of it. And because of that, and because of that being a right that our, 250 years now that we've had our United States, it's based on those kind of ideas. The idea that you are given the right to be heard. And that was something that was denied to Mr. Klein. And so because of that, he should at the very least be given a credit for the time that he's in jail. Now, I know that there may be some counter argument as to him being held in Washington County, but I think that's something where whoever's going to finally calculate it is going to have to know those specifics. And that's something that we need to parse out. And I know some of the case law also indicates that, if say Meigs County had given him a bond and it was saying, oh, our bond, then we're good, or if Washington County, but it's something where ultimately what we're talking about is we just want Mr. Klein to be given credit where he should be. And that's the ultimate result of all this. We just want it to be fair based on what has actually occurred. And I'm sure Mr. Klein has a lot more he can say about it as well, but that's my position.
Okay, do you want him to make his statement now or wait till after the state has stated their position? Spots.
We'll wait until.
Okay. So the state's position with regards to what, if any, credit should be given for the 108 months I just sentencing to.
Yes, Your Honor, the state believes that he should not get any credit for any of the time that he has been incarcerated. The timeline of events is as follows and is outlined also in the state's brief. But on February 28, 2023, the state filed the motion to revoke community control. That's referred to as Exhibit A. The court then issued a warrant, which is referred to as Exhibit D in the brief. He then remained at large and subsequently committed new felony offenses in Washington County. Then he was arrested on those offenses in Washington County and remained continuously in their custody from February 8th, 2025 until January 30th, 2026. On January 30th, he was sentenced to a term of imprisonment. That's State's Exhibit E, and has remained in the custody of the Ohio Department of Rehabilitation and Corrections since that date. After learning that the defendant was incarcerated in Washington County, the Meigs County Sheriff's Office emailed the outstanding warrants to the Washington County Sheriff's Office on February 28th, 2025, requesting that they be lodged as a detainer, and specifically requesting notification when he was ready for pickup so that transportation could be arranged. We'll specifically note this was lodged as a detainer. The warrant was not executed at this time. Meigs County was not notified that the defendant was available for transport, and so no transport order was issued. As defense counsel spoke to, on June 27th, 2025, the Washington County Sheriff's Office transmitted a hit confirmation requesting verification.
What date was that?
What date?
What date?
July 27th, 2025.
Okay.
They transmitted a hit confirmation requesting verification that the Meigs County warrant remained active. That's Exhibit H. I don't have any information as to how the sheriff's office responded. But I do have information, which is State's Exhibit C, that on September 11th, 2025, the Meigs County Sheriff's Office noted on their workflow sheet and e-warrants that the defendant had been incarcerated in the Washington County Jail since February 28th, 2025, and that a holder had been placed on the defendant at the time of the arrest. Again, outlining that the warrant was not executed, just a holder was placed on him at that time. The state's arguing that he's not entitled to any credit, as revised code 2967.191 requires jail time credit only for confinement arising out of offense for which the prisoner was convicted and sentenced. Further, the state has given case law, State v. Carpenter out of the fourth district, to Meigs County case, provided that that revised code is not intended to provide duplicate credit against unrelated criminal cases, and an offender is not entitled to jail time credit for any period of incarceration that arose from facts that are separate and apart from those in which his current sentence is based. It's inapplicable when they're imprisoned as a result of another unrelated offense, and there's no jail time credit for time served on unrelated offenses, even if that time served runs concurrently during the pre-detention phase of another matter. In that case, the appellant was arrested on April 19th, 2016 upon an indictment for a 2016 case, which were forgery counts and a cash bond was set. He was then picked up on a warrant for failing to appear in a separate case in which he was given an OR bond. Long story short, he asked for jail time credit. The court determined that there was no jail time credit for time served on unrelated offenses, even if that time served ran concurrently of him being incarcerated. So he was incarcerated on the 2016 case, but was given an OR bond on the 2014 case. That's applicable to this case in the sense that he was arrested for the Washington County charges. A holder was placed, the warrant wasn't even executed. There was no bond, nothing was given on the probation violation, but he still remained incarcerated for Washington County during this time. Further, the state cites State v. Copus, which is another fourth district case, referencing State v. Fugate, that Fugate does not negate the proposition that revised code 2967.191 does not entitle a defendant to jail credit for incarceration of unrelated offenses. In that case, the appellant argued that the court erroneously lumped together all of his jail time credit in two case numbers and then applied it to only one case number rather than applying the credit equally to both cases. The court did sentence the appellant to serve concurrent prison terms, and the jail time credit was only applied to one case. However, the court decided that the facts of that case were different than that of Fugate because in that case, the defendant was not sentenced for any new crime. Instead, there was a revocation of community control because of illegal drugs in his system, not because a new case arose. Whereas in Fugate, the defendant was serving community control when he was indicted for a new charge. He was then revoked on that community control for that new charge. So the court determined that there should be jail time credit because it all arose out of the same event. That's not the case here. So nothing in the record establishes that the defendant's confinement during that period arose from the Meigs County community control violation. Rather, his incarceration resulted exclusively from his arrest, prosecution, conviction, and sentence on unrelated Washington County felony offenses. The state also argues that since the warrant was never executed, that criminal rule 4 was never triggered. He remained continuously in Washington County's lawful custody on unrelated felony charges until his transfer to the Ohio Department of Rehabilitation and Correction following the sentence. And in Moody v. Daggett, they hold that a parole violator warrant lodged merely as a detainer does not trigger the immediate due process protections applicable to revocation proceedings because the warrant had not been executed. Court reasoned that the defendant's loss of liberty resulted from the new criminal conviction and not the unexecuted detainer. Criminal rule 4 here imposed no obligation on Meigs County to conduct an initial appearance while defendant remained in the lawful custody of another jurisdiction. Therefore, the state is arguing and would ask the court to reference the brief and all the exhibits that there shall be no jail time credit awarded in this case. Thank you.
Okay, Since it's your burden on this, do you want to argue more, or are you going to call your client again to testify?
I guess what I would do, Your Honor, is I'd like to call my client and I think he can address some. He's also been very involved in trying to understand what's going on and what his rights are and what the actual law says. I'm pretty impressed with him being able to actually do research even while he's been imprisoned. So I think he'd like to be heard.
But go ahead, Mr. Klein.
Well, the facts on the record here in Meigs County is that on February 26th or 27th of 2023, you had signed issuing a warrant for my arrest for courts, which was initiated on March 3rd. Timestamps commanding any sheriff's department, state of Ohio, to arrest me and bring me before the court without an unnecessary delay. Under RC 295108. However, I do have an arrest record here that was presented from the state on my journal here. It's whited out, doesn't show the 8 records for me.
I'm not sure I understand what you're saying, and I don't have that.
Yeah.
Is that attached to their paperwork?
Yeah, I was gonna say,
Where
Your
does it-
Honor,
what exhibit is it?
it's Exhibit G. He's referring to Exhibit G.
Let me
And-
find that then.
Yes, Your Honor.
I don't mean to interrupt you, but I want to see what you're referring to. So I have Exhibit G.
I also have a copy of my arrest record from Washington County that has the new charges I caught in result to the 4 probation violations I was arrested on and held without bond. On the same day at 5:08, Lieutenant Randy King made contact in response to, I do not have access to whatever John Archer sent her in advance to it, but he notified the Meigs County Sheriff's Department. I'm assuming because of the question asked on site that they made contact with Mr. Wilford and he never responded. In return, they did make notification to the Meigs County Sheriff's Department, and I have a copy of the response from Lieutenant Randy King stating that let me know when he's settled in, booked in, and I'll be there, make arrangements Monday morning to come pick him up, which triggers criminal rule 4. Okay, you got 2 court days to bring me before the court. The 295108 is a 3-day notification to make contact with the probation department, let him know, hey, we have him. The 30-day window isn't to delay courts from bringing me before the court, it's to allow Mr. Wilford to make plans for a hearing. Criminal Rule 4 gives the Sheriff's Department a much quicker response to it. I'm sure the state knows that. But I also have signed, time-stamped information where it was put on record, signed by the judge, journalized. Signed by you, Your Honor, I'm sorry.
That's all right. I was going to ask you which
Wrong
judge.
purpose.
I'm sorry. I was going to ask which judge because you had the judge in Washington County you referred to.
Yeah, it's time-stamped 2/28/2023. The warrant ordered and signed by you, and it's on the journal making that original billable order. It also says order to revoke community control is granted. Never had a hearing on it at that point in time. Okay, understand that.
I believe it's referencing that the warrant, the request for the warrant was granted, just for clarification.
No, it actually says, a bench warrant commanding the arrest of David Klein forthwith and that he be held without bond. The order to revoke community control heretofore permitted and finds that said motion is well taken and same should be and hereby is granted.
Yeah, that references the motion for warrant, just for clarification. That's the intent. So when it's granted, it's for the warrant to be entered in, but go ahead.
And also connected.
Because
to
you would have
that-
a completely separate hearing on that, on the motion to revoke both.
Okay, connected with that is also the warrant being issued on March 3rd by the Sheriff's
And
Department.
I can't see what you've got there.
Correct, but it's on my journal. It's where I got this information
Okay,
from.
okay, all from the journal.
Yes, and it's time stamped, electronically signed by you, journalized, with the commanding any officer, any deputy sheriff or officer in the state of Ohio to arrest me and bring me before the court without unnecessary delay. That's also timestamped March 3rd, 2023. Off of you issuing the warrant for my arrest through the clerk of courts. And I do have a copy here where the contact was made with Lieutenant Randy King. The date of arrest was February 28th, 2025. Return response from Lieutenant Randy King to 2825 at 5:08 p.m. stating the warrants are active, hold without bond, making arrangements to pick up. This triggers criminal rule 4. And honestly, the state failed to act, violating due process act rights. Again, it's not my fault. I understand it may not be the public or the probation department's fault, but somebody failed to act. That shouldn't be held against me. At that point, nothing happened. I just sat there. Nobody made any notification to me about anything going on to do with probation violations, except for when I was arrested and detained at the scene. That I had active warrants out of Meigs County and was going to be detained because of those warrants. And I was. However, as a result of that, I caught the new charge, wasn't convicted till nearly a year later. And I sat incarcerated in the Washington County Jail and was told 2 or 3 different times by Corrections Officer Coons, Corrections Officer Rayner, that Meigs County would be coming to get me within 24 to 48 hours. It never happened. I heard that twice. I heard that when I was initially arrested, and I heard that again in June. Now, the whole issue to do with June is that active warrants were faxed to Washington County, not made active. They were already active. And just because the deputy that arrested me did not have those warrants in hand, he confirmed that they were active. Execution of those warrants when I was placed under arrest and taken to the jail. I just don't feel that that should be held against me because somebody failed to act, not me. Until I made notification to the court that, hey, this was made active again, February 11th, 2026, when I got the CRC. I was accompanied by a tablet, and on the tablet in my sentencing records, it says I have a new active warrant out in Meigs County for a probation violation under 295108. And again, nobody acted upon it until I got to my parent institution and I made notice of it.
And when was your notice sent?
Excuse me?
When did you request the hearings? I know that at some point you did.
I mailed it out. It was the beginning of May.
May of 26.
Yes. And I know that when those hit the docket, that triggers the time that everybody's been notified. Yeah, it was journalized, timestamp May 18th, 2026.
Okay, thank you. All right, anything else? I haven't heard any arguments either way on whether the 108 months that I've sentenced him to on the violation should run concurrent or consecutive with the prison sentence that he's now dealing with out of Washington County. Does the state and defense want to be heard on that issue?
Yes, we would.
The state's position?
The state would ask that it was run consecutively with his Washington County case.
Because there has to be reasons for consecutive sentences. You don't just do it because you want to. I mean, the sentencing standards talk about when consecutive sentences are appropriate and when concurrent are appropriate.
The state's asking for it to run consecutively because these warrants had been out and he failed to, well, they were out because he failed to show up to STAR. The state then put a warrant out for his arrest. He knew that he he knew that he didn't go to STAR, he knew that was a violation, he still absconded from custody. And then while he was out, supposed to be doing these things, he committed more crimes, which has resulted in his Washington County case. These are the four case, there are four case numbers here, starting in 2019. So the state of the position that the defendant continues to commit more crimes, as evidenced by all of the case numbers here in Meigs County and as evidenced in Washington County as well.
Okay, and the defense position.
Yes, Your Honor. Of course, we would ask the court, I mean, we wouldn't be here if we all agreed on what everything should happen. I mean, we wouldn't want to speak about it. And so, of course, we feel that concurrent sentence is the appropriate sanction. The situation is, as I understand it, that normally courts are going to do concurrent as opposed to consecutive unless there are reasons why it should be to the contrary. And the situation is that Mr. Klein is already facing some pretty extensive time in his Washington County case. And as I stated earlier, and some of our other arguments about other things, essentially, Mr. Klein is still wanting to have a situation where he would be able to essentially have a life after all this is done. And the lengthier the sentence, the harder it's going to be for him to move forward in his life. Since courts decided that it should be 108 months, that's over 8 years. And that is a pretty lengthy time to be run after his already lengthy sentence from Washington County.
What's his out date in Washington County?
2044, so we're already talking quite a few years. So if you add 8+ more on to the end of that, that's probably beyond his possible lifetime. And I don't think that anything that he was found guilty of here previously, along with what happened in Washington County, is such that he should not be able to have a life once he's done. I mean, I'm certain that because of the kind of charges he's had, he will get PRC, and because of the PRC, I'm sure that there will still be supervision once he gets out. And so we would ask the court to take that into consideration. There was something just bookkeeping wise that my client also wanted to address, and that is some of the exhibits I think that were provided. There was some information, most information was blacked out, including like his record and that kind of thing. And I think he.
Have you asked
to have access?
Did you
to
ask
that.
for discovery to look at any of those things?
I didn't
Unredacted?
know that he wanted it till today, so I will see about that. But anyway, I just in terms of that, but like I say, going back to the whole thing, I'm sure that Mr. Klein is remorseful, and that this is a situation where, you know, it's a hard situation for him any way you slice it, whether he accepts everything and says, yeah, okay, you know, just sentence me and that's fine, or whether you say things were done wrong. Either way you slice it, he's coming out not well. And I think we would just like the court to give him an opportunity to try and move on.
Right. Thank you.
Yes, I don't, he probably has something to say.
Did you have anything else you wanted to say?
Just the fact that the state's violating my due process rights, and want that noted on record. And that being there's been no hearing, as any evidence admitted or even questioned about as to if I did or did not turn myself in, and the answer to as why, which would be
There was testimony that you didn't turn yourself in from the probation officer.
yes, but there's never really been any reason as to have any hearings as to why.
Well, now's your
So,
opportunity. Now's your opportunity if you want to tell me why.
I'm just stating the facts about my due process rights.
Okay, not about why you didn't show up for your star 3-day detainer or anything.
No, we should have had that hearing considerable amount of time ago, back in probably March of 2025.
I understand that's your argument, okay? Anything else?
No, ma'am. Thank you.
Okay. I'm gonna find that Meigs County was without the ability to deal with probation violation unless Washington County released him to us because he caught a completely separate, to use this term, he was indicted for a completely separate crime. It wasn't that he was being held only on this motion to revoke community control. He doesn't get, basically double dip on this. His time for the Washington County case took as long as it took. But I think, however, the time would start to run from the time he notified the court in May of this year. So, and I am looking at the purposes and principles of felony sentencing and specifically looking at whether or not this offense should run concurrent or consecutively. Certainly, considering whether to make them consecutive or not, the court would have to find it's necessary to punish him and protect the public from future crimes, and it's not disproportionate to the seriousness of the conduct and danger posed to the defendant and one of the following. And so clearly these offenses were committed while he was on community control, one after the other after the other. Also, his criminal history demonstrates that consecutive sentences would be necessary to protect the public. However, these are felonies, 4th and 3rd degree, but it shows, clearly you were just getting more and more serious in your criminal activity and your criminal behavior. But nevertheless, I'm going to order them consecutively. I take it back. I meant concurrently. I'm going to count them concurrently because you have such a long sentence already on your Washington County case. And I'll note the objection of the state on that. So your time will start when you notified the court, Meigs Common Pleas Court, that you wanted to be heard on your motions to revoke community control, and you'll vote for a period of 108 months because you've been given opportunity after opportunity after opportunity to comply with probation and to make sure your life became non-criminal, and only to just be involved in a more serious offense, even that resulted in a significant jail sentence till 2044. I don't even know, that's unusual. These were drug related offenses too, right? Yeah. So you're sentenced to 108 months, and it starting the day you filed to have these cases heard. And we'll note objections on both sides for potential appellate purposes. And you'll be remanded to the custody of the Meigs County Sheriff. I will need to advise you, however, one more time that because you are getting a prison term in this case, you may be subject up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You also have to pay the court costs in this case. And the date, as I said, the date for credit to start will be the date that the court docketed your request to be heard on the motion for summary judgment. You also have the right to appeal this court's decision. Any appeal, I said summary judgment, I meant motion to revoke community control. You have the right to appeal this court's decision. Any appeal must be made within 30 days after your sentence, which is what we're just doing today. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. And if for clarity, I'm clearly finding that Meigs County could not have you until Washington County released you to us. That's why the holders are put on, and until or unless you were released to Meigs County, there was nothing Meigs County could do about the cases. So I appreciate that you did finally notify the county, that you knew, I'm sure you knew long before that, but that you knew you had serious matters that had to be dealt with here. And so we're glad to have this concluded today. With that, you'll be remanded to custody. Thank you. Mr. Petroff, you have your other plea of guilty ready,
Yes.
and that is. Who's yours?
Hunley.
Okay, thank you. I have not obviously seen anything from that because you just worked it out today. Yes, did they send me the factual stuff too? Did you- Okay. So he's getting sentenced to the whole 36, the maximum with a judicial at 24.
Want to some cons.
So you've already gone through those papers with him? Yes. Sir victims.
I worked for someone around in 2018.
He's that.
If you want to watch him over, get him brief on the session, because that's how we're down again, but.
This way, this way. I'll get, this way, this way.
I understand.
No.
My mother, no. Not my home.
It's over there.
It's hard to understand.
I'm sure they're giving decisions filed for like 30 days to make that.
That's what we were just talking about.
We have seen this position more than 30 years.
Yes, exactly. Better get it through the door locked again.
I know, take a deep breath. Hmm.
So now we have it.
Okay, yes, it's like, you can, it's legible.
Brooke. Yes.
Right, it's anything, it's about there, she didn't do, it's your call, I can't do it, but if you say so, I can see if they're still involved, it's totally.
I mean, as long as you keep them completely separate from each other, I don't care.
Okay, yeah, I can't do it, but if you say so.
That's fine. That's fine. Go ahead and have a seat. I am ready on Hunley whenever. We are on record in the Meigs County Common Pleas Court in State versus Hunley, case number 26 CR 044. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yeah,
State your name.
Jay Hunley.
And your address was provided, I believe, on a piece of paper. So I have that. Is that information you put on that piece of paper accurate?
Yes, man.
Okay, and your attorney's going to identify himself for the record
Scott Petroff on behalf of Jay Hunley, seated to my left.
and for the state.
Yes, Chandler Sidney White, Meigs County Assistant Prosecuting Attorney on behalf of the state.
Thank you. We're here, Mr. Hunley, today. We're originally scheduled for a status or pretrial hearing of some sort, but I understand you've been able to reach an agreement between yourself and the state to change your plea from not guilty to guilty as to count 1. Is that correct?
Yes, man.
In order to complete that process, I'll have to ask you a lot of questions. So first, can you hear me?
Yes.
At any time, if you can't, let me know and I will amplify my voice more. And so if you can't hear me, just let me know. If I ask any question that does not make sense to you for any reason, ask me to restate, explain, or ask that question in a different way. Do not answer a question unless you understand the question. Will you do that?
Yes.
And if you need to talk to your attorney at any point, let me know that, and I'll let you step out and speak to him privately. So you'll let me know if that happens. Lastly, I need you to answer all questions out loud with real words. I know you started, the first one's yeah, they're yes, they're no, they're not, yeah, no, nope, you know, use real words because we are making a record. So with that, is there anything preliminary from the state or defense?
No.
Nothing to affect Your Honor.
There's no individual victim in this case, correct? Or is there? Obstructing official business, failure to comply, and resisting.
There was it's a fleeing.
Yes.
So there, you're saying the failure to comply? Are you referring to as a fleeing? Yeah.
A victim.
Well, there was a victim in that, some damage.
Yes.
Okay. Because there was an accident. So was that victim notified? Yeah, because we need to make sure that's the case.
Yes, Your Honor, that victim was notified.
You're gonna have to speak up. It's not coming through.
Yes, Your Honor, that victim was notified.
Okay, and is the victim present?
No, Your Honor.
Did you expect the victim to be present?
No, Shelley does not expect the victim to be present.
Okay, was the victim of the offense notified and given an opportunity to be heard regarding the plea agreement specifically?
Yes, Your Honor.
Okay, and has the victim communicated any objection to the terms of the plea agreement?
No, Your Honor.
Okay, thank you very much. Okay, with that then, if you would please state your full name, including any middle name, Mr. Hunley.
J. Garland Hunley.
J-A-Y, and
Yeah.
Garland is spelled how?
Garland.
Okay, and last name?
Hunley, Hunley.
Thank you. Have you ever used any other names, aliases, or nicknames, or are you a junior, senior, first, or second, or anything like that?
No.
Is English your first language?
Yes.
Are you the same person that's in the indictment in case number 26 CR 044?
Yes.
How old are you?
44.
What is your date of birth?
7/21/81.
What are the last four digits of your social security number?
8258.
How far did you go in school?
11th grade.
Can you read and understand written English proficiently?
Yes.
Have you ever served in the military?
No.
Are you a citizen of the United States?
Yes.
Are you under the influence of drugs, alcohol, or other mind-altering substances at this time?
No.
Do you now have or have you ever suffered from mental illness or mental disease?
No.
Are you presently under any type of probation, community control supervision, or on paper in this or any other state?
No.
Has anybody threatened, coerced you, or made you enter into this plea of guilty?
No.
Has anyone promised you anything at all if you enter into the plea of guilty?
No.
Listen carefully. The state is going to explain on the record what they believe they could prove if the matter went to trial and what the plea negotiation results are, and then you'll be asked more questions. So with that, go ahead, Ms. White.
Yes, Your Honor. This case were to go to trial, the state believes that we would approve count 1 of the indictment, which states that on or about the 16th day of April in 2026, in the county of Meigs and state of Ohio, Jay Hunley did commit the crime, the failure to comply with order or signal of a police officer, and that Jay Hunley did knowingly operate a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop. The operation of the motor vehicle by the offender caused a substantial risk of serious harm to persons or property in violation of section 2921, 331B and C5 of the Ohio Revised Code of Felony of the 5th degree, or a felony of the 3rd degree. And the facts that give rise to this case are that on April 16th, 2026, Jay Hunley was parked at Rejoicing Life Church and was passed out in the car in the parking lot. Molly Hash called Middleport PD to report the person nodding off, and when Middleport Police Department arrived, they ordered Mr. Hunley to get out of the vehicle, and after they ordered him out of the vehicle, he sped away. Mr. Hunley then began driving around 55 miles per hour at a 25 mile per hour zone and started passing vehicles, almost hitting a guardrail and running a red light. As they passed the marathon in Pomeroy, Ohio, Mr. Hunley was going around 70 miles per hour and continuing to pass vehicles and running red lights. Mr. Hunley then went past another vehicle driving towards oncoming traffic. He then locked his brakes and skidded 181 feet and hit the first vehicle head on. The vehicle that he struck was driven by Madison Enos, and her 3-year-old daughter was also in the vehicle. They were both transported to the hospital after the crash. After striking the vehicle, Mr. Henley then put the car in reverse, but was blocked in by Officer Harrison. Harrison then opened the door of Mr. Henley's vehicle and was able to pull him out after he resisted by holding onto the steering wheel. And with that, the state believes that it be able to prove beyond a reasonable doubt count 1 of the indictment. And the state would ask that the court go along with the agreement of the parties, which is that upon defendant's plea to count 1 of the indictment, the defendant shall be sentenced to 36 months incarceration. The state would not oppose judicial release after the defendant has served 24 months with release into the STAR program and then successfully complete inpatient treatment. Upon defendant's plea to count 1 of the indictment, the state would then move to dismiss counts 2 and 3. And the court shall impose a class 2 license suspension, which is 3 years to life, and the defendant also agrees to be assessed the court costs in this matter.
Anything to add to that or clarify by defense?
No, this is clarification, John.
Thank you. Mr. Hunley, the state has read into the record the plea negotiations. Did you hear what was said?
Yes,
Is that the same information your attorney discussed with you before the hearing?
yes,
Was anything different?
no,
Was anything missing?
no,
Do you have any questions about the recommendations?
no,
Have you read the plea agreement?
yes,
Has your attorney read it to you or reviewed it with you?
yes,
Do you understand what it says?
yes,
Do you have any questions about it?
no,
Do you understand that while you and the state have presented to the court a recommendation for sentencing, the court does not have to accept it?
yes,
Now, knowing the court is not obligated to follow the plea recommendations, do you still wish to proceed?
yes,
Do you understand that there could be a pre-sentence investigation report prepared for consideration at sentencing, especially, and would have to be if I was considering giving you a community control sentence?
yes,
However, the agreement is for a term of actual incarceration, so you're not anticipating or asking for a pre-sentence investigation report, is that correct?
yes,
Okay. Is that correct from your standpoint too, Mr.?
Yes, sir.
Do you understand this is a jointly recommended or agreed sentence?
yes,
Do you understand what that means?
yes,
Have you had enough time to consult with your attorney before proceeding?
yes,
Has your attorney answered all of your questions?
yes,
Have you reviewed the discovery, indictment, and other legal documents with your attorney?
yeah,
Ms. Whiting, has the state of Ohio disclosed all Brady materials?
Yes.
Mr. Hunley, are you satisfied with your attorney?
yes,
Do you understand the allegations contained in count 1 of the indictment are that you did on or about the 16th day of April 2026 in Meigs County, Ohio, commit the crime of failure to comply with an order or signal of a police officer, and that you did knowingly operate a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by you cause a substantial risk of serious physical harm to persons or property in violation of section 2921.331B and C5 of the Ohio Revised Code, being a felony of the 3rd degree.
yes,
Do you have any questions about the elements of that offense?
no,
Do you understand if you plead guilty to this offense, you'll be making a complete admission that you committed the allegations contained in the indictment?
yeah,
Do you understand if you plead guilty, the court will enter a judgment of guilt against you and proceed to sentence you immediately?
yes,
Do you understand that if you did wish to pursue an affirmative defense, it would be your obligation to prove the existence of that affirmative defense to the jury by a preponderance of the evidence, although it always remains the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
yes,
Do you understand by pleading guilty, you're waiving your right to appeal any adverse evidentiary or other pretrial rulings, such as the denial of a motion to suppress or the like?
yes,
Do you understand by pleading guilty, you're waiving your right to have any pending evidentiary motions ruled upon?
yes,
Do you understand by pleading guilty to count 1, the possible penalties that could be imposed would be 9, 12, 18, 24, 30, up to 36 months in prison, up to a $10,000 fine, or both?
yes,
This is not an offense, however, which carries a mandatory prison sentence. So do you understand the court could consider placing you on a community control sentence?
Yes.
You understand court could also consider you for things like judicial release and other early release programs.
Yes.
Do you understand you may be eligible for earned credit against your sentence depending upon the nature of your conviction and your conduct while in prison?
Yes.
Do you understand that as additional financial sanctions, the court must order you to make restitution if appropriate?
Yes.
Do you understand that restitution means compensating the victim based upon the victim's economic loss?
Yes.
You understand the court will determine the amount of restitution you have to pay and will conduct a hearing to determine the exact amount if necessary.
Yeah.
Given the fact that there was the head-on collision, is there restitution being sought or just potential civil separate?
There's no restitution being sought.
Okay, thank you. Mr. Hunley, do you understand, unless waived, the court will be ordering you to pay the court cost?
Yes.
Do you understand that your right to operate a motor vehicle in the state of Ohio will be suspended from anywhere from 3 years to life?
Yes.
Do you understand that you may have to serve a period of post-release control as part of your sentence after you're released from prison?
Yes.
Do you understand that period of post-release control is discretionary? It's not mandatory or required, but if imposed, it's for a maximum of 2 years.
Yes.
Do you understand that if you are placed on post-release control under the authority of the parole board, you could be returned to prison for up to 9 months for each violation of the rules if your stated prison term equals or exceeds 18 months?
Yes.
Do you understand you can be returned to prison for up to 50% of your prison sentence for all violations committed?
Yes.
Do you understand that as a condition of your post-release control supervision, after your release, the adult parole authority may require you to wear a GPS electronic monitoring device of some sort?
Yes.
Do you understand that if you're convicted of a new felony while on post-release control, that in addition to being punished for the new offense, upon proper proof, the sentencing court could add an additional consecutive or stacked prison term of 1 year or what time remains on your post-release control term, whichever is greater?
Yes.
Do you understand the offense to which you're pleading carries a neutral classification with regards to sentencing, which means that there's no presumption that you should have community control, but there's also no presumption that you should have a prison term?
Yes.
Do you understand that the court can consider placing you on a community control sentence for up to 5 years?
Yes.
Do you understand that if you are placed on a community control sentence, you would have to abide by all the probationary conditions as established by this court?
Yes.
Do you understand if the court places you on a community control sentence at any point, for a felony offense, a prison term will be reserved as the underlying term?
Yes.
Do you understand that if the court places you on a community control sentence at any point and then you violate the rules, violate the law, or leave the state without permission, the court can impose more restrictive sanctions, including the imposition of local jail time or other residential sanctions, may extend your probationary term to the maximum, or even impose all or part of the reserved sentence?
Yes.
Do you understand that you may or may not be eligible for judicial release?
Yes.
Do you understand that while you may file a motion for judicial release, there's never any guarantees the court will grant your request?
Yes.
Do you understand the court would have to have either a pre-sentence investigation report or a post-sentence investigation report to even consider a request for judicial release?
Yes.
Do you understand this court cannot accept your change of plea unless you understand you're waiving important constitutional rights?
Yes.
Do you understand you have the right to a trial by jury of 12 people?
Yes.
Do you understand that all the jurors must agree that the state of Ohio has proven your guilt beyond a reasonable doubt before you can be convicted?
Yes.
Do you understand that at trial, it is the state of Ohio that has the obligation to prove your guilt beyond a reasonable doubt as to each element of each crime of which you are charged?
Yes.
Do you understand that you have the right to the assistance of an attorney at your trial?
Yes.
Do you understand your attorney has the right to confront, cross-examine, or ask questions of any witness who testifies against you?
Yes.
Do you understand that you have the right to compulsory process, which is the right to compel, require, demand, or make witnesses attend the trial through the issuance of subpoenas to make sure they are in court when you need them?
Yes.
Do you understand you cannot be forced to testify against yourself at trial?
Yes.
Do you understand you have the right to testify if you want after consulting with your attorney?
Yes.
Do you understand if you elect not to testify at trial, your silence cannot be used against you in an attempt to prove your guilt?
Yes.
Do you understand each of these rights?
Yes.
Do you have any questions about any of these rights?
No.
Do you understand if you plead guilty, you'll be waiving all of these important constitutional rights?
Yes.
Do you understand by pleading guilty, you'll lose some of your civil rights, which means you may not vote, serve on a jury, hold public office, or work as a public employee, and you may be denied a license to engage in certain professions?
Yes.
And in this particular case, is this a firearm disqualifying event? I don't believe it is. Or it is?
It is.
Oh, okay.
Well, under federal law, it's not free,
Oh, okay.
and he is already firearm disqualified. I've gone over the firearm disqualification issue with him.
Okay, great. Thank you for doing that. And you understand then that you'll be prohibited from owning, possessing, acquiring, or using a firearm?
Yes,
Do you understand that even though Ohio does permit terminations of weapons disability under certain limited circumstances, you'll be subject to prosecution under federal laws unless you obtain a separate relief from disability under federal law?
yes,
Do you understand you may or may not be eligible for an expungement or sealing of your record at a later date?
yes,
Do you understand that your right to vote is suspended while you're incarcerated, but can be restored or is restored upon your release from confinement, even if you're still on parole, post-release control, or community control?
yes,
You understand, however, your voter registration is canceled upon conviction and you must re-register before you can vote.
yes,
Do you understand your right to serve as a juror or to hold public office is not restored until you receive a final release from the adult parole authority or complete all post-release control or community control sanctions?
yes,
Do you understand that you are prohibited from circulating or signing nominating petitions, voter registration applications, or ballot initiative petitions?
yes,
Do you have any questions about these civil right consequences to your plea?
no,
Do you understand if any fine, court cost, restitution, or other financial sanctions ordered in connection with this conviction remains unpaid, the state of Ohio may place a block on your ability to register your motor vehicle or transfer its title until the amount is paid in full?
yes,
Do you understand that if you hold any professional licenses in Ohio, including but not limited to license to practice medicine, nursing, law, pharmacy, social counseling, teaching, or to serve as a peace officer, this conviction may be reported to your licensing board and may affect your ability to keep the license?
yes,
Do you understand that if you plead guilty, that constitutes a complete admission of guilt and that the facts you're admitting to today may be used against you in a subsequent civil lawsuit brought by the victim of this offense?
yes,
Do you understand that the victim retains the right to sue you separately in civil court for compensatory damages, including medical bills, property damage, lost wages and pain and suffering, and punitive damage for intentional, malicious, or egregious conduct?
yes,
Do you understand any restitution this court orders does not prevent the victim from seeking additional damages in a civil action?
yes,
Do you understand all these potential civil liabilities?
yes,
Do you understand you do not necessarily lose your right to appeal if you plead guilty?
yes,
Do you understand, depending upon the outcome of your case, you may possess the right to appeal this court's decision?
yes,
Do you understand any appeal in a criminal case must be filed within 30 days after you're sentenced?
yes,
Do you understand if you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds?
yes.
Now's the time where I want you to tell me in your own words what happened on April 16th, 2026, and where it happened. I want to make sure there's a sufficient factual basis to accept your plea. So tell me where you were and what happened.
Lead and eluding, fair to signal and, was in Meigs County.
So let's talk about
Yeah,
a
break it
little
down.
bit about where you were the day that this happened. You remember the day that this happened?
Yeah,
Where were you at?
I was at the gas station,
What gas station?
I think it's Sunoco,
Is that here in Pomeroy or
Yeah.
Middleport?
Middleport.
Okay, and what were you doing in your car?
I was sitting there GPSing how to get back home, cause I was on my way to work in, Mount Deer.
Okay, and you pulled, and we had talked about this, you pulled out of the gas station, right?
Yeah.
And at some point you did see the car, the police car behind you with the lights and
Right.
sirens, correct?
Right,
Right, you saw that and you didn't stop when you
Right.
saw that. You kept going,
right,
you blew through some lights,
right,
you slammed on your brakes,
right,
had an accident,
yeah,
and that happened in Meigs County, Ohio.
right,
And were you using it at excessive speeds
yes,
and were deliberately trying to outrun them
yeah,
and did cause serious harm to a person or property?
yes,
Okay, thank you. Do you have any questions for the court before we proceed?
no,
Do you want to talk to your attorney more before we proceed?
no,
Have you had enough time to think about this important decision?
yeah,
Are you certain this is what you want to do?
yeah,
When you first came before me on the indictment, I entered a plea of not guilty on your behalf, so that we could proceed with your assistance to counsel and so on. Before I can accept anything different than not guilty, you first would have to withdraw the not guilty plea. At this time, do you want to withdraw your not guilty plea?
yes,
Now, what is your plea to count one, failure to comply with an order or signal of a police officer, a felony of the third degree?
guilty,
I have in front of me a written plea of guilty. And on page 3 appears some signatures. Does that include your signature?
Yes,
And on page 4 appears signatures under the waiver of jury trial and acknowledgement of rights. Does that likewise include your
Yes.
signature? Did you sign the written plea of guilty and the waiver of jury trial and acknowledgement of rights knowingly,
yes,
intelligently,
yes,
and voluntarily?
yes,
Therefore, let the record reflect the defendant has made a knowing, intelligent, and voluntary decision to withdraw his previous plea of not guilty, now tender a plea of guilty to the crime of failure to comply with a signal or order or signal of a police officer, a felony of the 3rd degree. The court finds that the defendant has been informed of all of his constitutional rights, that he understands the nature of the charge, the effect of the plea of guilty, as well as the possible penalties that could be imposed. Therefore, the court accepts the defendant's plea of guilty in this case, just one, and finds him guilty of the offense of failure to comply with an order or signal of a police officer, a felony of the 3rd degree in violation of Ohio Revised Code section 2921.331A. And with that, I believe the state will have a motion.
That's trying the state would move to dismiss counts 2 and 3.
No, any objection?
No objection.
Okay. The court is prepared to proceed to sentencing as the state
Yes, Your Honor.
is defense counsel. Mr. Hunley, do you have anything to say regarding why the sentencing hearing should not proceed at this time?
no,
Prosecution's position again?
Yes, Your Honor, the state would again ask that the court go along with the agreement of the parties, which is that following the defendant's plea to count 1 of the indictment, the defendant shall be sentenced to 36 months incarceration, and the state would not oppose judicial release after the defendant has served 24 months with release into the STAR program and then successfully completing inpatient treatment. The court shall also impose a class 2 license suspension, which would be 3 years to life, and the defendant also agrees to be assessed the court cost in this matter.
All right. Do we have a victim impact statement since there was a victim?
We do not.
You didn't? Okay. And defense counsel then?
Yes, Your Honor. My client is essentially accepting the maximum penalties here. I'm gonna make a few arguments that I wouldn't normally make in this situation, so bear with me. My client has an extensive criminal history. It's not something.
I was going to ask you that because I get those typically if I know there's going to be a plea.
Right. So normally I wouldn't be trying to argue to the court that my client has an extensive criminal history, but he has an extensive criminal history. He was not out of prison for an extended period of time when this happened. He's been in this sort of cycle that we often see where people are sent to the prison and then just set free, settlers, without any sort of programming, without any sort of transitional care or anything of that nature. The very first time I talked to my client about this case, he was immediately remorseful and willing to plead. One thing that he had asked for was if he wanted the opportunity to have some sort of treatment or some sort of opportunity to step down from prison to a facility so that he could sort of transition back into society. That's why the offer here, what we negotiated, is for the state to not be opposed to a judicial release into a CBCF and then transitional into inpatient. 36 months, he's already been sitting, he's not going to get any jail time credit. So he's essentially, when he applies for JR after 24 months, he's going to also get 6 months at CBCF. So it's not like he's reducing the sentence by a great deal.
So he's
with the
being
JR.
held on PRC and not us. Is that
He's not
right?
being held on PRC.
Oh, he's not. So he will get credit for time served.
yeah.
So as it relates to, let me clarify, as it relates to the JR. So when you apply for a judicial.
Oh,
release,
okay, I see what
You
you-
don't get credit.
I thought you were
for the
saying you
local
wouldn't.
time.
Okay,
No, so
okay.
I actually clarify. You don't get credit for the local time that you're sitting.
Right.
When you apply for.
Actual
JR.
24 months in.
Right, he's gonna have to do an actual 24 months
In prison.
plus he's been sitting. Plus JR provides that he goes to CBCF. So in reality, he's gonna eat up most of that 36 months. But the reason for the request from JR is to allow him to transition back into society. So we'd like the court to keep that in mind when we do apply for JR. So, and
Do you have his criminal record that I can look at? Because I usually.
I received it as part of discovery.
Yeah.
It's extensive. I worked for an office that used to represent in 2018, so I know that.
Look at it. Then arresting that you got the same attorney again. So Circleville and Franklin County. Thank you. I just want to see what types of charges. So a lot of thefts and receiving stolen property, failure to comply, and firearms violations. It looks like primarily. Thank you. Thank you very much. All right. Mr. Hunley, do you have anything to say on your own behalf or to present any information in mitigation of punishment?
No,
The court must consider certain things before imposing sentence. In this case, the court does not have a pre-sentence investigation report to consider, but is considering the Rule 11F statements, the sworn testimony, the record, and other relevant information. The court has formulated its decision based upon the three overriding principles and purposes of felony sentencing, which are to protect the public from future crimes by the defendant or others, to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanctions the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitating the offender, deterring the offender, rehabilitating the offender, and providing for restitution if it were sought. The court has also made sure the sentence is not based upon any impermissible purpose. The sentence is consistent with other similar offenses committed by like offenders. The sentence is proportional to the harm caused and impact upon the victim or victims. The court has considered the seriousness and recidivism factors which may be applicable, as well as the fact that this is a felony of the third degree, which carries that neutral classification with regards to sentencing. That is no presumption of community control, but also no presumption of a prison sentence. With all those considerations, nevertheless, and pursuant to the agreement, the court is finding that a prison term is consistent with the purposes and principles of felony sentencing and does sentence you to 36 months of incarceration. And the court understands that the part of this agreement is that the state is not going to object to judicial release after 24 months of actual incarceration in the state prison system. And with that, the request would be then to go to a community-based correction facility like STAR and successfully complete that. And then from there to an inpatient facility to try to get you the help necessary to get you back in society in a more successful manner than what happened last time. I do have to advise you again that since you are going to prison, you may be subject to up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control terms may be added as an additional consecutive penalty. You also have to pay the court costs in this case. You will get credit for time served towards the whole 36 months, but not towards the 24 for the judicial release part of your agreement. You will have your license suspended for a period of 3 years. So after you're out and back integrated in society, you can try to get relicensed. You have the right to appeal this court's decision. Any appeal must be made within 30 days after you are sentenced. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
no.
Okay. Anything else from defense
Nothing from that job.
and from the state?
No.
All right, then we'll remand you the custody of the Meigs County Sheriff to start your sentence, and I'll wish you well.
All right,
And with that, the next hearing is a domestic violence case, so I am taking us offline.